Item 1.
The block grant employee looking for a direction for grant the pensioner benefit. And your lordship, the Hemanta Kumar Chotra case that is posted to second week of December. And your lordship is disposing the subject to outcome of that. Here he has not filed any representation.
Petition where reads as well. Alternate HEA, Mr. Lanka appearing for the witness points out that the writ of mandamus should be preceded by the demand and rejection, or in the demand. First, in support of this reports, Justice B.L. Hansaria's writ jurisdiction under the Constitution of first, the reports in this sense. Next one, the petition is disposed of, reserving liberty to the petitioner to make an appropriate representation to the jurisdictional peace, and if one is made, decision shall be taken within a period of 8 weeks thereon. First, all contentions are kept open. No cause.
Item 2.
Please, Your Lordship, on behalf of Mr. Devendra Nath, my lord, here is the petitioner prays for arrears salary that has been withheld, wrongly applying the ratio.
Something.
My lord, Your Lordship already disposed of.
What order we have made to consider the representation?
Yes, Annex 3 is pending, madam.
Sub item also same, my lord.
Same order.
My lord. And item 12 and 13 also same.
13 also same.
12 and 13.
12 and 13.
My lord.
Okay.
Item 3.
Problem.
Item 3.
Here he has prayed to accept his application for VRS. His representation at Annexure 5 is pending at page 9.
He does not want to work there.
No, a criminal case is pending against him.
That's all right.
Yeah.
But how that comes in the way?
Yes.
You consider this at least.
Representation.
Petitioner is complaining against complaining before the writ court against non-consideration of his application dated 16/6/2025, a copy whereof avails at Annexure 5, wherein he has requested for the permission to retire on VRS basis.
Yes.
First time. Where an application of the kind is given, it is the bounden duty of the officers to take a call thereon without keeping it in limbo eternally. First stop. Next one. Learned AGA, Mr. Lenka, on request appearing for the OPs, very fairly submits that he would instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation if all contentions are kept open and a reasonable period is prescribed. First stop. This is appreciable. Next paragraph. 6 weeks.
Item 4.
My lord, I may be permitted to submit virtually from Bhubaneswar. In the present case, the petitioner is an assistant teacher in a ME school who joined in service in the 1971 and retired in the year 2009 June.
Why is your petition?
No, against the final order.
Final order you have come.
Yes.
Take notice then.
Yes, sir.
The Lenka is requested to accept notice for OPs. Yes, next.
Item 5.
It's also covered by the.
My lord, Hemant Kumar Chotra, subject to outcome to read up to.
You have copy of here?
Which is pending of this in division bench, subject to outcome of the writ of copy.
What is it?
Last layer. The relief granted to the petitioner is subject to outcome of writ appeal number
197. 197.
Item 6.
May I please, Your Lordships, I'm in the virtual mode, my lords.
Yes.
My lords, herein I'm challenging the interim notification wherein the land which belongs to me has been shown by in the comprehensive development plan as a green zone. So this issue was before Your Lordships in another writ petition, which is WPC 29088 of 2025. And Your Lordships were pleased to issue notice and it's pending, my lords.
Right. Issue a
By
learned
For one,
AGA requested to accept notice for one, emergency is to the rest, to the other. So that call this matter along with WP number.
29088 of 2025.
Next. Item 7.
Deeply obliged.
These are matters challenging the demands under the Odisha Irrigation Act in respect of groundwater of a coal mines.
Similar
My learned
matter
senior
similar
will-
meeting, na?
My lords,
Issue
your
emergency.
lordship was fixed to 19th January.
19 January, along with WPC number 21153 of 25.
I would tell you.
Emergent notice, learned AGA is requested to accept notice for OPs. Only 2,
My lords,
3 OPs. First stop. Yes, you have sought for any interim prayer?
my lords, interim.
An application in A number so supported by affidavit is moved seeking a stay of impugned proceedings. First off.
Impugned demand,
For
my
the
lords.
impugned demand notice. First off. Learned counsel for the petitioner submits that in identical matters, that is WP number so and so, so and so.
21153 of 25.
Been granted and therefore similarly needs to be extended to his client on parity basis. First off. Let it force in this submission.
Item 14 also says.
Okay. In the above circumstances, the application having been favored, the demand notice is kept in suspended animation. Okay. Call this matter along with the WP number
21153.
By 25.
14.
Same. 14 also.
14 is also same.
So, item 8.
The petition joined as Suchasabhi Sikha on 1/2/2004 and became a regular teacher on 1/2.
Any representation is given?
No, my lord. My lord, here I have retired, my lord. That
You
will
have
also
retired?
kindly come to page 15, my lord. Clause 2. The government has framed the scheme. The contractual schematic period of all teachers in elementary schools should be counted for their qualifying service towards retirement benefit. They should not claim area financial benefit. Their contractual and schematic period, my lord. Therefore, my period from 1 to 2004 is taken into consideration. I can get the pension. I am not getting the pension, my lord. And retirement duty, my lord. The lordship issue notice, my let them file it.
Yes, issue notice. Lenka accepts notice for all this. Item 9.
May I please, Your Lordship?
Yes.
Your Lordship, I am working as a classical Sanskrit teacher. Your Lordship, challenging here in the petition, I am challenging the arbitrary withholding of my salary.
22, 13, 9, 20.
Yes, Your Lordship.
They are not given the salary to you.
Yes, Your Lordship. Lordship, in the month of March, I am in leave, Your Lordship, due to my husband's illness. But after that, COVID-19 lockdown was started, Your Lordship. For which I am unable to return.
Let them take a decision on your Annexure 7 representation.
Your Lordship, Annexure 136, Your Lordship. Annexure 136. Annexure 1, I have made a representation to DEO. And 3 and 6, Your Lordship, I am made a representation to collector, Your Lordship.
DA to take a decision.
Who has to take the decision?
Your Lordship, the authority is DEO and collector.
Both they will sit across the table and take the decision.
No, Your Lordship, then DEO. Your Lordship.
Short grievance of the petitioner is as to non-consideration of his representations at annexures 136 and 7.
7 is RDC.
All right, 136. Respectively dated so and so.
wherein she has sought for releasing of withheld salary for a particular period. First off, counsel for the petitioner vehemently argues that payment of salary is a sine qua non of employment, and without any justification, a salary payable to an employee cannot be withheld. First off, in support of his contention, he quotes Article 30 rule enacted in Article 23 of the Constitution of India, as has been widely interpreted by the apex court in the state of Gujarat versus the High Court of Gujarat, right? 1997. Next one. Learned AGA Mr. Lenka, appearing for the OPs, very clearly submits that he would instruct the jurisdictional OPs to look into the grievance of the petitioner as has been reared in the subject representations in a time-bound way if all contentions are resolved. First off, he also requests the court to prescribe a reasonable period for accomplishing the task. First, this is appreciable. Next paragraph. 4 weeks. Open to solicit, etc. Delay shall be viewed very seriously. Yes. Item 10.
In this case, OP3 to take this up.
OP3 instruct OP3 to look into this.
Yes, here the petition is a retired primary school
Make use
teacher.
of mic. I have some hearing problem because of cold.
So this petition is a retired primary school teacher. Here the juniors has been promoted, but he has
not been given promotion.
Given promotion.
Promotion to which post?
Promotion to headmaster.
Headmaster.
Yes.
Is it seniority come merit or merit come seniority?
Merit.
Merit.
Merit and seniority.
Merit to due regard to the seniority.
Merit come seniority.
And admittedly, the person who is below in the gradation list was promoted.
No, but if it is merit come seniority,
Then the
that
government has decided to give promotion on the basis of
you look into that grievance.
Mr. 8 is pending.
yes,
Short grievance of the petitioner sought to be made out before the writ court is as to non-consideration of his case, his or her his case for promotion to the next level when juniors have been accorded. First, counsel for the petitioner draws attention of the court to the representation dated 8/4/2025, a copy whereof awaits at Annexure 8, wherein, in that regard, request has been made to the Director of Elementary Education.
OP2.
OP number 2. First, counsel submits that where such a representation is made, it is the bounden duty of the officers to look into the grievance of the petitioner. And that having not been made, a direction at the hands of this court is eminently warranted. First, Learned AGA Mr. Lenka, in his usual fairness, agrees to instruct the OP number 2 to look into the grievance of the petitioner, as has been held in the subject representation in a time-bound manner if all contentions are kept open and reasonable period is prescribed. This is appreciable. Yes. Yes, sir.
I'm not threatening school. Making the pension is already adjourned to 18th August. If that has not listed your loss.
At least
Not listed your loss.
in the first week of January, we will take that matter. First week of January.
No, my lord, before that, if the reading is not completed, then that will be adjourned to January. Before vacation is also clear.
Call it after 2 weeks.
One day your loss. One day your loss was that is not listed your loss.
Some date due. It was. Oh, this is.
May I please, Your Lordship? Here, the Lordship, the petitioner challenges the order dated 3/9/2025.
Remember,
Issued, yes, Your Lordship, issued by the Bhubaneswar Development Authority for a revised, directing the petitioner to file the revised order of his judgment.
revised order.
Revised order of his judgment and a decree dated 22/9/2005. Let me submit the fact of the case, Your Lordship. what happened in the case, in the year 1978, the Bhubaneswar Development Authority, earlier it was known as the Bhubaneswar Regional Improvement Trust. They constructed some houses for the development or establishment of the township. So at that moment, one person, namely Banshidhar Parida, on his application, a house was allotted on the basis of on installment basis. So after payment of some installments due to his financial
So what
difficulty,
is this revised order? Order of the court is eternal. Unless it is set aside or it is time bound.
Your Lordship may issue the private party also there.
For one, emergent notice to the rest.
Item 12, 13 question have been disposed of. Item 15.
Telling the approval order annex of 3 million, which has been done in absence of the present petitioners who are the mutuality of the masjid million. Against that order, we have filed a petition before the opposite party number 2 under annex 6, which is pending before the authority. Till date, no decision has been taken with regard to the objection filed by the petitioner.
Matter is pending.
Yes, madam.
You want
Before-
direction to dispose
Yes,
of that?
yes, madam. Annex 6,
Go to prayer.
madam. Lordship is 12, madam. Since same has not been approved by the opposition in accordance with law, dispose of the representation filed by the petitioners. In the approval order, it is.
But your prayer is different.
No, my lord. Last,
Huh?
in accordance with law, my lord, second para. Direction may be issued to the opposite party number 2 to dispose the representation filed by the petition.
That serial number you are looking at.
Item 15.
15, page 12, my lord, my prayer.
It is therefore prayed that admits
Second para, last one.
please to issue writ of mandamus in quashing the impugned order, which has not been approved with representation.
Yes.
Petition prayer reads as a first. Counsel for the petitioner submits that regardless of textual nature of the prayer, his client will be satisfied if OP number 2 is directed to dispose of the representation dated
Dated 3/4/2024, my lord. Under annex 6.
3/4/2024, a copy whereof awaits at Annexure 6, wherein he has requested for cancellation of approved management committees and for postponement of further proceedings of masjid in question. First time. Learned AGA appearing for OP numbers
1, 2.
OP number 1. Submits that the decision has to be taken by the other authorities and therefore that his client has no role to play in the matter, especially the functioning of the other authorities under the provisions of the Waqf Act 1997, 95. Now new act has come now. 1995. First notice next paragraph. Notice to OPs, other OPs is dispensed with since petitioner's prayer is for an order to pass an order on the subject representation, keeping open all contentions of the parties. First time. He also asserts that the said representation is still pending consideration on the file of OP number 2. First, next one. In the above circumstances, the petition is disposed of, directing OP number 2 to pass an order on the subject representation in accordance with law after giving an opportunity of hearing to all the stakeholders. First of all, contentions are kept open. Compliance to be done within 8 weeks. We'll make it 3 months.
3 months.
8 weeks. 8 weeks.
2 months.
Registry to send a copy of this order to OP numbers 2 to rest of private also.
First one. Next paragraph, last. Since this order is made ex parte, the ex parte, qua OP numbers 2 to so and so, comma, it is open to them to seek recall of this order if grounds do exist therefore.
Item 16.
My lord, the petitioner was appointed as an assistant professor of physiology by the Annexure 2, page 1920, serial number 20, Dr. Shila Lipit Pradhan. Assistant professor of physiology for a contractual period of 4 years.
4 years.
4 years. My lord,
They are not accepting his duty report.
no, she submitted the joining report, but the dean and principal rejected the joining report with a ground that she has not produced a relief order. Relief order means earlier she was also working in the MKCG Medical College, Barampur, and she was relieved by.
Relief order is produced.
Yes, relief order was produced, my lord.
Why did
Annexure 3. She
take notice?
Yes, sir.
Short matter. We'll call this matter next week. Yes. Issue emergent notice. AG is directed, is it requested to accept notice for all three?
Yes, no, Dean.
Only dean and principal, Maharaj Jojati Kesari Medical College. Government, actually the dean is not accepting the joining report.
All right. Are they government officials or the private? Any
government official.
You accept notice for all?
Yes.
Notice for all. First one.
Yeah, Annexure 7. Annexure 7, legible copy maybe.
Legible copy. Even I cannot read that.
Yes.
I'll give a legible copy. I will show.
I think short grievances involved on this matter on 23rd. Okay.
Item 17.
In this case, the similar order, similar cases, is to issue notice in the other cases, that is to, there is a reappeal held before the Sonal Court, and that was allowed, and the petitions are on same footing. So, this would be given the preference with regard to that reappeal for which the petitions can be for mailed.
Babita to take notice. He is requested to accept notice for copies. Okay. Next.
Item 18.
3 cases are same.
And you can continue. In other matters, what we have done? In other matters, we directed consideration of the representations.
He has not filed any representation.
You have not filed any representation?
No.
You file representation, they will consider in the light of that Babita.
That can be disposed of.
With that,
Petition, all these petitions are structured on similar facts. First, prayer in the petition is for a direction to appoint, direction for appointment as Speaker Sahib under any of the government schemes in the light of DB judgment dated 23/12/2020 in writ appeal number 701 of 2020 between Babita Satpathy versus State of Odisha. First off, learned AGA points out that ordinarily petitions of the kind shall not be entertained in as much as no representation has been filed by any of the petitioners, and therefore officials will not be able to do anything. First off, there is force in this submission. He assures that if petitioners make appropriate representation supported by evidentiary material, there would be no difficulty for considering the same in a time-bound way on merits. First off, this is absolutely clear. And counsel for the petitioner is agreeable with that proposal. Next one. In the above circumstances, petitions are disposed of, reserving liberty to the petitioners to make appropriate representations as indicated above.
OP3.
And if one is made, if one is or made, ONES, the same shall be decided by OP number 3.
Yes.
Keeping in view the decision in Babita Subra within a period of 8 weeks. All contentions are kept open to solicit. Okay.
Item 18. All cases. Abandon all cases. Also.
My lord, also say HK Hemant Kumar Chotra.
Representation is pending before the quiz manual 3. Consider the bench.
Subject to outcome of that one.
Do you have that copy of the judgment?
My lord.
You have changed the factors. The subject matter of this petition is substantially similar to the one in WP number 1625 of 2013 between Sri Sarat Chandra Parida versus State of Orissa, heard and disposed of by a coordinate bench of this court-wide judgment dated 8/5/2014. First, at the next paragraph. At the para 9 of the judgment, it is observed as under. First. Next paragraph. Learned counsel for the petitioner submits that if case of the claim is considered in the light of the said judgment, justice would be met to him. First. Next paragraph. Learned AGA Mr. Lanka appearing for the OP submits that the said judgment is put in appeal and therefore hands of the OPs are tied. First one. When asked as to whether any interim order of stay has been obtained, in all fairness, he says that there is no such order. First one. Next paragraph. In the above circumstances, petition is disposed of, directing the OPs to accord OP1 to accord the same benefit as has been granted to the petitioners in the said case, subject to outcome of
W. Read the number.
Hemant Kumar Chotra. Is pending in the case of Hemant Kumar Chotra. Sarat Chandra Parida's case is
finality.
It has already attained finally.
Sarat Parida case was dismissed because of delay in the Supreme Court. Yes. Issue itself.
But issue is same.
Yes.
Issue is same. Subject to that writ.
Elaborately, it has been passed by this coordinate bench.
What is that writ appeal?
197/2024. Hemant Kumar Chotra.
Appeal. That's right. So between Hemant Kumar Chotra, State of Odisha versus Hemant Kumar Chotra. One, two, next.
Item 19.
19, my lord, on behalf of DK Mahapatra, prefer tomorrow or next week.
19.
Yeah, representation is pending, my lord. It is one representation is
not. Petitioner is the craft teacher. If not upgrading post is not be sanctioned, petitioner is not be allowed to upgrading post your lordship. We are challenging the petitioner who is to continue as a craft teacher in the school of the Deep Sundar.
You want absorption and upgradation.
My lord.
Let them consider where is your representation.
I have not filed any representation.
You have filed representation.
Yes.
You have not read your own papers.
No, I have not read.
Petition prayer reads as under. Petition is preceded by the presentation of a representation dated
9/6/2025.
14/6/2025. 14/6/2025.
14/5 years. 14/5/2025.
Page 5 is there.
Where is it? And it's a 10th.
And the 10 page 47 you will submit.
Yes. 15/5. 14/5.
14/5/2025.
Wherein a request is made for absorbing the petitioner in the vacant post of senior SCS, but into brackets headmaster, stroke principal, bracket full. In school for the deaf at Sundar. First, the net counsel for the petitioner submits that no decision is being taken on the subject.
Same benefit also granted to this school, own school.
Although similar benefits have been granted to other similarly circumstanced employees. First one. He submits that if a direction is issued for consideration of the subject representation in a normative way, justice would be made to his claims. Agrees to instruct OP number.
He has not made the party to whom he has represented. Let him face representation before OP1.
No, there is a representation. Yes, that is the OP number 225. OP number.
He has not
agrees to instruct the jurisdictional OPs to look into the grievance of the petitioner if a fresh representation is given.
Yes.
Supported by evidentiary material. First off, with this proposal, counsel for the petitioner is agreed. Next paragraph. In the above circumstances, petition is disposed of, preserving liberty to make a fresh representation, and if one is made, a decision thereon shall be taken within a period of 8 weeks, keeping in view all relevant factors.
Interim application is there not to put in advertisement. Consider the request.
Kept open. I have to insignificance in view of disposal of the main matter. Next. Item 14.
In this case, the petitioner is scheduled caste person. I've been financial assistant in the year 1999 from the Odisha Scheduled Caste Scheduled Tribe Development Financial Corporation. Thereafter, he has paid substantial amount, but so out of due to outstanding rupees 97,000, certificate proceeding has been initiated. And in the certificate proceeding, the petitioner made an application since the agricultural process has of the year 1999 has now is a distress condition to pay the principal amount with some interest. The certificate officer has not considered the request. Thereafter, petitioner approached this court. This court directed to consider the petition grievance for one-time settlement. Thereafter, the order of this court has been communicated. Certificate officer was under Annex 1 directed to approach the district welfare officer, who is the managing director of the corporation. And managing director of the corporation says, you approach the certificate officer. Therefore, my claim could not.
No, you have taken money. Pay back.
Well, that is the question.
That's the law.
That is the law. But the poor scheduled caste person.
He may be poor, he may be scheduled caste, scheduled tribe, he may be a Brahmin, or he may be Kshatriya, Shudra.
That is
the law is law. That is
money is that is the under the beneficial scheme.
Show the rule which says it can be given one-time settlement. Like bank rules, RBI guidelines.
Authority will consider.
Consider means where? He will give you concession and it becomes precedent for other people. It's all our money.
That is the law. But sometimes considering the predicament of the.
So where is the law? Where is the law which gives the power to condone or reduce payment? You will install. Where is that power?
That power vested with the authority.
Show that.
That authority can
Show that. I will direct him right now.
But authority has not taken any decision.
Why he should take decision? Show the law which says that he has to take a decision.
Every financial assistance matter when the or at the
May sir. If your lordship will please let the matter go to the Lok Adalat.
Lok Adalat.
Again.
No, why it should go to Lok Adalat? He has borrowed money. He will not have the sense to pay back. So that that money can be given to other SC/STs.
In loan matters also, matter is being referred to the local.
No, I don't agree with that. Otherwise, he will eat the entire money, which otherwise can be given to other SC/ST people.
One fact, the principal amount will be 97,000.
Maybe it's all a mathematical calculation.
That's
Maybe
right.
97. You have no interest. You have no interest to pay back the principal. Now your principal is that you should pay the interest.
More than thrice of the principal.
It may be. Dam Dupat is applicable only as amongst Hindus.
That is the law of the land. I am not. This is the contractual obligation of the petitioner. But sometimes
I am dismissing the petition. Otherwise, it becomes a wrong precedent, and other scheduled caste people will be affected. This money is not to eat away.
If possible, some kind of sympathy has to be taken to the.
You show me sympathy by doubling my salary.
Yes, and
waiving the loans which I have taken. Because I am doing even when I am not well, show sympathy to me.
That I have considered.
It is not possible. Suppose this is money meant for scheduled caste, scheduled tribes. You are a member of scheduled caste and you have taken that money. You honestly pay back that money so that your other members of the scheduled caste, scheduled tribe will be benefited.
But sometimes the principal, when continuing, the excess interest burden is affecting the party. That's why I maybe it is can be compromised through mediation or then I am permitted to withdraw my letter.
Petitioner is permitted. Petitioner, having argued the matter at length vociferously, now seeks leave of the court to withdraw the petition so that he can explore other avenues for redress. First, petition is accordingly disposed of. First, registry to send a copy of this order to all OPs by speed post. Okay. You cannot do that. What other SC/ST should do?
That is your lordship.
Next.
Item 21.
Your Lordship, my learned senior counsel's father is admitted in hospital, so this matter will be taken.
I will assist you. Start our treatments. Give our file. What is this matter about?
So the petitioner has been qualified from B.Ed in the year 1997, and he was joined as a LSES cadre on the year of 2003. However, according to the Rule 15 of the Odisha subordinate rules, so he was supposed to get.
You are fully prepared without turning pages, also arguing the matter. Wonderful.
I was aware about the facts. So yes, so according to the Rule 15, after 3 years of mandatory.
Yes, counsel Mr. So and so, who argued very well, even without turning the pages of the paper book. First off, made out a case for issuance of emergent notice. First off, issue emergent notice. Learned AGA request Mr.
1 to 3.
Requested to accept notice for 1, 2, and 3. Emergent notice to 4. What's your name?
It is Nandita Behera.
Yeah, you argued very well.
Okay.
Yes, give back our file. You may carry it with you in your vanity bag. Yes.
Item 22.
Now the matter on behalf of Mr. S.K. Sahu, the matter is.
This is all about similar with serial number 18, my lord, that.
In the similar matter, there is notice was issued.
Notice. 18 we have disposed of, na? Subject to.
They are also sending this.
We'll dispose of that matter in terms of 18. All right. This is Martin. Same as in
Item 23.
May I please, petitioner filed this application for passing of the personal proceeding on the ground that the criminal case, the petitioner was acquitted the criminal case, same charges and a similar fact of the evidence, and the Lordship
departmental proceeding to be quashed.
Lordship, the charges of Annexure 1 for page number 14, Lordship, may kindly receive.
1-4.
1-4.
What is that?
Demand charge claim of the demand and acceptance illegal gratification of rupees 10,000 from the complainant. That is the vigilance case at the acquittal judgment Annexure 4.
Acquitted.
Acquitted.
Is it the case of honorable acquittal?
Not so honorable acquitted.
Sure.
May kindly. Finding of the judgment, Lordship.
Yeah.
That's page 58.
Page 58. Turning page 58. Considering the overall circumstances, it is held prudent that the prosecution has not been able to prove the case against the accused beyond all reasonable doubt, which is the cardinal principle of a criminal jurisprudence. Lordship,
it is for want of evidence.
There is a...
See, in criminal law,
yes,
the degree of proof is very high. Proof from guilt to the guilt. But in disciplinary proceedings, it is not like that. This is number one. Number two, the observations made by the learned trial judge, they do not give rise to an honorable acquittal in the light of Ramlal.
Lordship, decisions are the honorable.
Where is the honorable acquittal? In Ramlal, they have said only in such and such circumstance it will be on the case of Honorable P.V. Rudrappa. Not otherwise. This is not a case of that kind.
The same fact of evidence and the same fact of...
No, not like that. Same facts will be giving rise to one disciplinary inquiry, another criminal prosecution. The agencies are different. Quality of evidence is different. End product is different. Here, dismissal or such other punishment. Here, going to
conviction or acquittal.
That's different. Okay.
The Honorable Supreme Court has already been decided the Ramlal with honorable acquittal and a
Where is the honorable acquittal? That's what I am asking you.
No, on benefit of doubt and honorable acquittal, distinguish the...
Benefit of doubt is not honorable acquittal. Therefore, I have said in P.V. Rudrappa, we have enlisted 5 circumstances when it will be treated as honorable acquittal. We have that P.V. Rudrappa versus State of Karnataka.
Another decision affects court. Maharana Pratap Singh versus State of Bihar. Disciplinary action cannot be upheld when the employee was acquitted in criminal case.
That is
over the similar evidence, similar fact of case, similar charges of the...
No, I don't know. It's not like that. It is already interpreted. Just look into this judgment. Give copy of this judgment. Give Xerox copy of this judgment. You just look into and come back a week.
Yes.
Okay?
Yes.
What's the citation? P.V. Rudrappa.
Item 24.
This is relating to RSC, my lord, and covered by the Saraswati Bhoi, my lord, which has been affirmed by the Honorable Supreme Court.
Yesterday, similar 6 matters are there. One is as
representation date will same.
Date same day.
Same.
Item 25.
I may be pardoned, my lord. I am in VC, my lord.
Yes.
Lordship, I have filed an IA, my lord, that has not been tagged with the writ petition, my lord. So that may be taken up, my lord. The matter will be taken up tomorrow.
Direction to include in the
matter of selection, my lord. Interim order is necessary in this matter, my lord. That is why I have filed an IA.
Or tomorrow. Registry to post IA. Yeah.
My lord, IA number, my lord, 22254 of 2025. That may be tagged up.
Yes. That IA has not come today.
Obliged.
Item 26.
Six. What is annexure 3? Go to annexure 3.
This is a representation to the authority concerned by the principal cum secretary against one of the lecturer of the college. There are other similar 2 to 3 matters are pending in respect of the same college, same principal.
Take a decision on that. Director of Higher Education has to take the decision. Petitioner's representation dated 7/1/2025 on the copy whereof avails as annexure 3 seeks a disciplinary proceeding against a particular individual, namely Shri Prasant Kumar Mohan. First off, counsel for the petitioner submits that when such a representation is made, the jurisdictional OP, namely the director, higher education, take a call on the same within a reasonable time before the evidence is available on record whither away. First off, there is force in this submission. Next paragraph. Learned AGA Mr. Mohanty, although initially opposed the petition, now fairly agrees to instruct OP number 2 to look into the grievance of the petitioner in accordance with law in terms of representation. First off, he caveats that all contributions of the party should be kept open. First off, this is fair. Next paragraph. In the above circumstances and with the above observations, petition list is pulled on. Registry to send a copy of this order to OP number 4 by the speed post. Speed post. So that he can seek recall of this order if grounds do exist therefore.
Excuse me, I'm not written time.
No problem. Okay.
Item 27.
Answer 1, that is the punishment order that you appeal, my lord.
Punishment is what?
For disciplinary proceeding.
What punishment?
Punishment for page 1 increment.
Page 12.
Page 12, my lord.
But appellate authority also has appealed it.
Yes, ma'am. The one increment we stopped without cumulative effect, and the rupees 43,81,000 rupees to be recovered toward the cost of 15 quintals of rice.
Misappropriation 15 quintals of rice.
Rice. Yes. That is damaged by the insects, my lord. That is
insect which your client himself appears to be an insect. Who has eaten that?
My lord.
How 15 quintals of rice will be eaten by the insect
But it is kept called the hostel, my lord.
15 quintals, my lord. The headmaster.
Headmaster. After eating that, he has become insect.
And also, there is also the period of suspension may be treated as
How? You have been punished.
And the cross-examination.
What is the punishment?
Punishment is, my lord, one increment without cumulative effect.
One increment.
One increment only.
15 quintals.
Another is,
and the recovery.
43,000 some odd is to be recovered towards 15 quintal of rice at the rate of 2,870 per quintal. And period of suspension. These are
no, only I am praying for the suspension period. The
suspension period.
Regularize the suspension.
How to regularize? You are punished.
No, the two is not I am praying, but only that is the suspension period.
Nothing.
And also the witnesses, those who are also, they have said that it is during the storage while that rice has been damaged.
Why damaged? Why did you not take action to preserve that?
But he has also
not damaged, consumed.
No, my lord.
How can you say? You did not go for a lunch or dinner?
It was also physical. They are physical recovery, my lord. Physically, also the bags, and not he has misappropriate. And there also the hostel superintendent, the attendant superintendent who is in charge also, he has said that
petition
are also there.
First, in a properly constituted disciplinary inquiry, wherein petitioner participated.
He has also not given the chance to cross-examine the witnesses also.
Fortunately, participated. Come on. A punishment order withholding of one annual increment without cumulative effect and for recovery of the loss caused has been handed. First off, the departmental appeal against the same was turned down after perusing the records. First off. Next further. Counsel for the petitioner vehemently argues that no reasonable opportunity was given to his client, nor there is any material to connect the petitioner to the alleged loss in question, and therefore ensued orders are liable to be settled. First, learned AGA appearing for the OPs vehemently opposes the petition, contending that where a disciplinary authority has levied the penalty and the appellate authority having examined the matter has affirmed the same, the writ court should be loath to interfere. More particularly when the matter is one under Article 227 of the Constitution of India, Article 226 having been ornamentally employed in the pleadings. First, I agree with this view. Next one, in the above circumstances, petition being devoid of merits is liable to be dismissed, and accordingly it is. Courts having been reluctantly made this. Next one.
128. Madam Hemant Sudra. 28 and 34.
28 and 34. Same.
Item 29. 29, my lordship, Ashok Kumar Master. Both.
I will serve copy on the other side. How he will, you want to put him to this unnecessary disadvantage. Suppose if he files something tomorrow showing the online proceedings,
Oblige, madam.
To the coffee. Both matter same.
Item 30? Yes, may I please, Your Lordship?
Yes.
The petitioner was appointed as laboratory technician way back in the year 1998 in an aided Ayurvedic college. My lord.
Now you are seeking resumption.
Yes. My lord, the collector, initially I approached this honorable court by filing a writ petition. And this honorable court directed me to approach the collector. I approached the collector. The collector conducted an inquiry and directed the governing body of the college to take me back. That order is under Annexure 8 at page 41. Since there is no governing body, now, my lord, my only prayer is, Your Lordship may direct the principal of the college to
implement this order.
Implement this order. And in similar matter, Your Lordship has directed the collector to implement the order.
Because the body, governing body was not
in the absence of
yes. A coordinate bench has passed that order.
Similar order. Whichever is changed here.
Yes, Your
same
Lord.
order will do.
Yes.
Yes.
Item 31?
And this is a career advance from promotion to the post of professor from later.
From 8 years of service?
Yes, 8 years service.
8 years.
Similar judgments have been made and was made by Justice
Do you have copy?
Yes, I have an annexed copy also.
This has been annexed, my lord, at Annexure 10, at page 93.
The subject matter of this petition is substantially similar to the one in WP number 36285 of 2021, etc., between Dr. Dhirendra Kumar Dalai versus State of Odisha, disposed of by a coordinate bench of this court while order dated 27/11/2024. Full stop. Paragraph 8.2 in the said judgment reads as under. Make it complete. Below that, no other paragraph. The net counsel for the petitioner submits that his client having been similarly circumstanced, the relief accorded to the litigants in the cognate petition has to be extended to his client as well. First, learned AGA appearing for the OPs is not in a position to differentiate case of the petitioner from that of the cognate case. First, next part. In the above circumstances, this petition is disposed of with the direction to OP number 1 to consider claim of the petitioner to for granting benefit of professor scale of pay under CAS, Career Advancement Scheme. Career Advancement Scheme. In the light of observations made in the cognate case. First, this should be done within a period of 3 months. All contention are kept to. Next.
Item 32?
Yeah.
Petition has filed applied for certified copy of the certificate of the death and birth registration on the birth certificate of the petitioner son, my lord. There is some mistake while issuance of the certificate under Annexure 1. It has been the village name has been wrongly typed, my lord.
Name is wrongly typed.
Yes, my lord. Annexure 1.
What is his name?
Name is Ashish Barla, my lord.
What is wrongly written?
Wrongly reflected, Annexure 1 at page...
Aman Barla.
No, my lord. Place of the place.
My lord, it is not the name, it is the place.
Place of
That is Sunakhala, it was written in otherwise, my lord. It is by the CMC authority, in fact.
Bath and Register CMC.
Cuttack Municipal Corporation. Bath and Restaurant.
Short grievance of the petitioner is as to non-consideration of his request for change of
Place.
of birth.
Yes.
As reflected in the certificate of birth.
Right.
Of one Master Aman Barla. First one. Counsel for the petitioner points out that the place of birth is wrongly shown. That is that?
That is
Sukhanala instead of Sunakhala.
Instead of
Sunakhala.
Sunakhala. This is the right word. So for corporation, other layers are there.
Yes, ma'am. Panel of lawyers are there. OP number 2 is the appropriate authority.
Register.
Next slide. OP number 2, therefore, is directed to look into the grievance of the petitioner and do the needful without unnecessarily driving him to the court again. First off, the task to be accomplished within a period of 4 weeks. From the date a copy of this order is placed on his table. First of all, contentions are kept open. Next one, the registry to send a copy of this order by post to OP numbers 1 and 2. Immediately.
Item 33.
Materialist to Ashok Patra. Not similar, I think item 66, all the same manner.
But dates will be changed.
Yes, ma'am. 66, item 66.
66 also same.
Yes.
Item 34 has been disposed of. Item 35.
May I please, that's it. Let's see here the opposite party number 3 who is not taking action against the construction of the RD road, the proposed RD road, by avoiding to construct the 2-kilometer village road by diverting the fund constructing other side. The order has been passed cryptically. That is page number 25, annexure 6.
To complete the construction.
Yes, let's
What is the timeline for construction?
2 years is there, Your Lordship, and the kilometer is area is 1.5 to 2 kilometer. That's it.
Where is that 2 year?
Have a glance to the map, Your Lordship, under annexure 2, page number 16, Lordship. The dotted area, Luduhueri to Rajimera, that road has been not constructed, Your Lordship.
Earlier, they were before the
coordinate. It ends, Your Lordship. And the order first, Lordship, by the order under annexure 4, considering the submission made and without expressing any opinion on the merits of the case, this court directs opposite party number 2 to take a decision on the above noted petition in accordance with law within a period of 3 months from the date of receipt of this order, Your Lordship. And after that, they passed the cryptic order under annexure 6, page number 25. Whereas the collector cum chief executive officer Jilla Parishad Gajpati in letter number 4252 of dated 7/12/23 issued instruction to the executive engineer RD division 2 Mohana to go ahead with the construction of left side bypass loop road for the village Bodrengi under the project, that is construction road from Lakripata to Luduhueri via Danges Khal for the welfare of general public. Whereas as against the value of rupees such and such deviation, excess value of...
Take notice. Lordship. You say what has happened.
Lordship, previously, my lord, there are 5 writ petitions there, my lord. And my lord, in pursuance Lordship's direction, they have passed the order.
Annexure 6 is the.
They have stated that the fund is not sufficient to construct that road. And they are diverting by constructing other side, Your Lordship, but not ignoring this 2 kilometer road.
No, how they will, how you will know where the road should be laid?
Lordship, the project is there, Your Lordship.
That particular 2 kilometer is also covered under the project.
That project, proposed area, Your Lordship. Yes, Your Lordship. Finally, we glance to page number 19, Your Lordship. That is written in Oriya, Gramya Unnayan Vibhag.
You want that
area to
construction of that 2 kilometer also?
Is it that? Yes, Your Lordship.
What they say, we will not, or we will.
We have not the sufficient fund to construct that road. When they are
So they want to construct, but funds are not available.
Not available, they don't want to construct that area. Your Lordship, by diverting other side, they are constructing other side. That is not under the proposed area, Your Lordship.
The construction where they are putting up that laying the road. It's not part of the project.
Yes, Your Lordship.
It is part of the project.
This village I am praying for is part of the village.
The other part?
They are intentionally trying to divert the fund from constructing that side.
You consider that representation?
Lordship. Yes, Lordship.
Which is that representation?
They are proposing a new site, madam.
No, madam is saying it is part of the project itself. Just examine. If it is part of the project, then undertake work there also.
Yes, madam. They are demanding for a road, madam. That will.
Because road
not road
is also Article 21 now. Road, river, everything we have brought under the umbrella of Article 21. Where is your representation, madam? Annexure 5?
That's Annexure 5, yes, Your Lordship. That is in ODI, Your Lordship.
Representation dated?
Let's see which date. The date has not been mentioned, but after having
you give representation.
Press representation.
You give fresh representation in English also.
Yes, Your Lordship.
All right.
Lordship.
Petitioner's undated representation at Annexure 5 in the vernacular reads as under. First, counsel for the petitioner submits that a stretch of 2 kilometers road, 2 kilometer road is a part of approved project, and therefore the construction activity in that regard has to be undertaken in terms of the project itself. She also points out that in respect of similar stretch on the other side of the project, which is not part thereof, the construction activity has been going on relentlessly, and therefore this court should come to the aid of the petitioners. Next paragraph. Learned DAC on request accepting notice for the OP submits that if a fresh representation is given with evidentiary material to vouch the claim, there would be no difficulty for the authorities to look into the grievance and take appropriate decision after giving an opportunity of hearing to the petitioners. First of all, with this proposal, counsel for the petitioner quarters. Next one. In the above circumstances, petition is disposed of with the above observations.
Lordship, the construction work is going on here.
Yes.
Item 36.
This batch of cases, there is another writ application bearing WPC 1203, where counter resolution filed, same order has been challenged, a verbatim same order. And a batch of cases, this relates to the case scale of profession. In fact, a judgment of profession, but to be placed in the scale of profession under career advancement scheme. The judgment was passed by this court in the main case. That case, in fact, they are passed the similar order, and these cases are only in terms of that judgment. And same order has been passed also. So, if the Lordship will, after vacation, any date, if you that matter, in fact, was in the list. 12303, where they have filed the counter, we have filed the rejoinder, point is very limited.
What should happen in this matter?
So all these matter may be connected to that so that also call
You can dispose of these matters so that those matters can be disposed of.
Yes. That
Thank you then.
Yes.
You. What is the grievance?
No, the grievance is this.
Yes.
You also kindly look to the judgment, batch of judgment, page 107, annexure 10.
Now, what is challenged here?
It is challenged the interim order annexure 13.
1.3. What does it say?
They say the counter they have filed in the previous judgment that has been quoted only, nothing else. You also look and just showing the that is at page interim order is page annexure 13.
This was a career advancement scheme benefit.
Yes.
Benefit under the career advancement scheme.
Under the career advancement scheme.
What was the benefit?
The benefit was that they should be placed after 8 years. They will be placed in the career advancement scheme. That is the person, those who are reader, in the rank of reader, after completion, they will be placed in the career advancement scheme. The case of the petitioner was...
If they are placed in that scheme, what would happen?
They will get the scale of professor scale. In fact, what has happened, 76 persons, they were junior to us, but they were placed in the career advancement. And immediately after we approached this Hon'Ble Court issued notice and passed a judgment in a batch of cases. And the main case is that case, WPC 1203. But directed that in terms of the finding of this Hon'Ble Court, let them take a decision. Now what they said, what this Hon'Ble Court has found, to negative that they have quoted the counter which they have filed in the earlier writ application. That writ application judgment I have given also at page 107. That is why I am saying because they have filed a counter in that case. So that you also can take up those matters.
Where is your entitlement to the benefit of scheme show that?
That's right.
Where is the scheme?
That is, in fact, if you ask me, the very same persons were petitioners is offshoot of earlier writ application.
No, that's all. No, where is the scheme?
Yes, that is there. That is, sorry. Just give it a chance. It's there. Let's give it. Yeah, sorry. That is, if you also will get it at page 72, that is the notification. Yes, you also kindly come to page 78.
78?
Yes, sir. The scheme of career advancement.
Minimum
this is the career advancement. Minimum length of service is in the grade of lecturer. Then we will also come to 713. Reader with a minimum 8 years of service in that grade will be eligible to be considered for appointment as a profession. That
people to be considered for appointment.
Yes.
Eligibility.
Yes, sir. Eligible. No, that is also there because.
If you pass,
yes, sir.
You become eligible to become
satisfied. Yes. The only thing is consideration. The consideration for placement in the place scale of profession.
No, that
is there.
Eligibility is one thing. Entitlement is another.
Can I? Because the judgment which now this is the offshoot of the earlier writ application. Yes, this has been argued also for this Hon'Ble Court. You also kindly come to page 107. 107.
Good.
Everything is there.
No, 107 said consider.
Please, sir, consider, but
nothing beyond that.
No, finding. That is finding is there. That is why I am saying this.
Finding saying?
Yes, sir. Saying that they are to be placed.
Sure.
Also come to page 114, having heard the learned counsel.
114?
Yes. Running page 114. Does you get it?
Yes.
Having heard the learned counsel appearing for the parties and considering the submission made, this court finds that the present batch of writ application have been filed inter alia with the prayer to consider the claim of the petitioner to get the benefit of professor scale of pay under career advancement scheme. Such a claim has been made basing on the notification by the UGC on 24/12/1998 and the acceptance of the said resolution by the government in the Department of Higher Education, resolution dated 31/12/99. though it is the stand of the opposite party that notification issued by the UGC on 24/12/98 has not been accepted by the government as yet, and the resolution dated 31/12/99 is on a different.
Yes, brother, come to 8.1.
Lordship.
At page 115.
My lord.
They say to many others you have already given.
Right, sir.
And why not to these people is their contention?
Lordship.
Your first contention was you had not adopted the UGC guidelines at all. But that has been rejected.
Lord, they have specifically stated the region, my lord. Lordship, kindly have a glance to page 124, my lord.
124.
124 of part of the impugned order, my lord. Last para, my lord, I am placing, my lord. And whereas the petitioner retired from service well before the promulgation of Odisha Education Service College Branch Recruitment Rule 2020, which came into effect on 18/2/2021, the promotion of 76 associate professors cited by petitioner made under the Rule 2020, which have prospective operation. As such, the petitioner having retired prior to the enforcement of the new rule is not entitled to claim parity with the officers.
When that CAS scheme was...
that is 98, 24/12/98.
24.
That is at paragraph 8.1. Lordship asked that question.
24/12/98.
Yes, sir. 98. 24/12/98.
And that was adopted by the government when?
That was adopted by the government in 2020. That is at page.
Adopted on?
On 21. Page
6 to 21.
Page 79/21. Page 76. 66.
79/21.
Yes, page 66. Annex 5.
When your clients retired?
Sir, I retired just before that. 20.
Then how they are entitled?
Sir, 98.
No, that is adoption.
That adoption.
1872.
Sir, this case is like this, sir. Sir, there it was specifically held that these also look to that paragraph. I'm reading just that judgment.
Those whom we are quoting to others, they were all during the service.
Sir, they were in service, but we have retired. But the date when they have given effect to that, by virtue of that resolution, we are in service admittedly, and we just retired in 2020. Just before that.
The question is not.
Sir, kindly look to page 81. That is the observation.
81.
81. That page 115, paragraph 8.1. I'm reading the whole. Though it is the stand of the opposite party that notification issued by the UGC on 24/12/98 has not been accepted by the government as yet, and the resolution dated 31/12/99 is on a different context. But this court, after going through the benefit extended in favor of the similar notification by the associate professor and notification.
Where are you reading that judgment?
Judgment.
Page number?
Page number 115.
115. Go to 115.
8.1, my lord. Such is that, in fact, the record was conferred, it was found that, say, 98 from the basis of that night. That's why look to that. On a different context, but this court, after going through the benefit extended in favor of similar situated associate professor by notification dated 39/2021 and the information provided on the RTI by letter dated 19/4/2023 is of the view that benefit of promotion to the rank of professor has been extended in favor of the associate professor by notification dated so and so under the career advancement scheme. Therefore, this court, by disposing of the writ application, direct the opposite parties, number one, to consider the claim of the present petitioner to get the benefit of professor scale of pay under career advancement scheme. It is observed that while taking such a decision, benefit extended in favor of similar situated associate professor by notification dated so and so, and the information provided, that is more important. Data later dated 19/4/2022 to the effect that such benefit has been extended under career advancement scheme be taken into consideration the proper perspective. Okay, number one.
Okay.
Sir, but I'm trying to impress yourselves. This is so far as that observation of this honorable court, they are not challenged.
The question is not that. Your entitlement is under a statutory scheme.
Sir.
The requirement is to be in service.
Sir.
For those who have left the service on attaining the age of superannuation, they can't come.
Sir, my case is my specific
judgments of the
Sir, I do. Sir, my case is the promotion is not a matter of right.
This is not promotion.
This is not a promotion. Career advancement. Sir, career advancement they must consider in terms of the law which was there on the date when they have become eligible.
Correct.
The question is they are not considered.
No, you were not eligible yet.
Sir, how? That is the question. Sir, in 98, if they have adopted that, sir.
Question is 98 is not the question. We'll go back to 1526 when Babar had come.
Sir.
The question is, was it adopted by the government?
Sir,
the cases of parity which you are arguing, they were all in service.
Sir, a question of adoption, they had adopted in 1998, sir. No. They were in service. Yes, sir.
24/12/98 was the policy.
Yes, sir.
17/9/21 is the date on which they adopted.
Sir, yes, sir. That you also look to paragraph 16 of my writ application. That must be kindly look to that. My specific case is this, sir. And that was also the...
16.
Yes, sir. That the University Grant Commission by notification dated 24/12/98 was pleased to let down the minimum qualification for appointment of teacher in university and colleges.
Named as UGC, so
yes, sir. In the said notification, the career advancement with regard to getting the scale in the appropriate post was laid down, and the petitioner has also satisfied the criteria of professor as laid down in the 98 notification. Copy of such notification is annexed to the annexes transfer. On the basis of the aforesaid decision, Government of India...
One second. Whether notification is applicable to the state teachers proprio vigor or it needs adoption by the state.
This is the state notification, sir.
Which one?
This one. This
no, UGC notification.
The next page you also look. That is the on the basis of the aforesaid decision of Government of India, on the recommendation of the UGC scale, the government the Government of Orissa opposite partner 1, taking into consideration the local condition, decided to implement the scheme of revision scale of paper college as well as university teachers with the following conditions.
With effect from
98, sir. Do you also see that? The revised scale also look to that the same page. The revised scale of pay shall be effective from 1st January 1996.
No. When this was adopted?
This was adopted, sir.
This was adopted on 17/9/2021.
No, sir. No, sir. No, sir. It is adopted in 1998.
Government has adopted.
Yes, sir. Yes, sir.
Where is that?
Sure. You also look to this. This has been annexure 7. Annexure 7, page 84.
31 December 99.
99. So just type, let me. The revision pay scale of minimum qualification for appointment teacher to the university and colleges and other measures. This is dated 31st December 99, after 98 also. The state government has decided to extend the UGC scale of pay with effect from 1/1/86, then para 2. The Government of India, after considering various recommendations of the UGC on the revision scale of pay of the university and college teachers, communicated their decision to the state government in the letter dated 27/7/98, are requested to implement the scheme by the state after taking the local condition into consideration, and with all conditions to be laid down in this regard by the UGC by way of regulation. Accordingly, UGC has communicated the notification of the revision pay scales, minimum qualification, and appointment teacher in university and colleges and other measures for maintenance standard 98 in the letter dated so and so, and requested to implement the scheme university and colleges. The question of revision scale of pay university and college teacher on the basis of
it is UGC scales of pay.
Sir, that is also their career advancement.
Show that.
Sir.
Nothing.
Professor. You also come to page 91. That the career advancement.
91.
Sir.
This is what?
The career advancement also look to that.
No, this needs to be adopted by the government.
Yes, sir. This has been adopted.
Very.
Sir, this is that resolution which I just now read.
No, that the word CAS is absent in that.
Sir.
Absent in.
So this career advancement is also within that UGC scale.
No.
Sir, that very resolution.
No.
Sir,
contrary to you are speaking contrary to the Supreme Court judgment.
Then you are saying keep it to some other day so that I can show you that this resolution itself has been adopted in large number of cases for career advancement.
If we are asking you,
sir,
show the CAS has been UGC has 16 sets of regulations.
Sir, I know that.
Question is whether CAS has been adopted or not is the question.
Sir.
That you are not answering. The government said, we have not adopted CAS scheme because we are a poor government. It is not some very rich government. Government.
If that is so, yes, sir. Sir, if that is the start of the state government,
that is
so far 76% where they have taken this decision that will be adopted from this date.
They were in service.
Sir, is it the case that those who are in service only they will be extended? Yeah, they could, sir. They have adopted this resolution, sir, for the purpose of extending that benefit.
They have adopted it on 17/9/2021.
21, sir, they have extended the benefit to those persons, sir. Those persons. But so far as this resolution is concerned, that 98 resolution which was accepted by her, sir, your service
made out and therefore dismissed with us.
I can't because the large number of cases.
See, I have read. I also come from service law background.
Sir, can I say, sir?
Next.
37.
That is my lord, higher scale, that is scale of pay, my lord. That is the highest paid scale of pay. The petitioner
I'll come back within few minutes.
Petitioner is appointed as a PT, my lord. PT.
Physical education.
Physical education. PT in 3/12/2011, my lord. That's after that the continuance of 6 years of service, that petitioner post has been regularized. Annexed 3, my lord. That is 29/5/2019, my lord.
Joined on
3/12/2011, my lord. Annexed 1, my lord. Page 13. Thereafter, at that time, it contractual, my lord. In Annexure 3, my lord, page 17, in 29/5/2019, my lord. The post has been regularized, my lord. 29/5/2019, my lord. At that time, my lord, that salary pay scale has been fixed. Matrix paid, my lord.
You are also regularized.
My lord.
Where is your name in that?
Annexure 3, my lord.
Annexure
3, page 17. Ramchandra Malik, my lord.
Ramachandra Malik.
My lord.
Now what happened?
That at that time, my lord, the pay has been fixed for matrix paid, my lord. The petitioner is entitled to ISC paid, my lord. That acquired the higher qualification BA BPED, my lord. That other districts also been allowed to draw the ISC paid, my lord. Or the judgment of Niranjan Naik case, my lord. That
higher pay scale is not given to you.
My lord?
Higher pay scale is not given to you.
Only matrix paid, my lord. The petitioner has acquired the BS BPED, my lord. That a higher scale.
entitled to higher scale. The other district, the Kalahandi district and Fulban district also allowed to ISCPAD, my lord, on the basis of Niranjan Naik case, that is ISCPAD. The coordinate bench also passed the order to draw the ISCPAD, my lord. That is annexure 6, my lord. I am annexing annexure 6.
That's 6. You are covered under that.
My lord.
Where is your representation?
Annexure 7, my lord. Page 32.
My lord. Page 32.
Right now.
The opposite part of 2, my lord.
Petitioner's representation dated 26/7/2025. Seeks scale of pay bit higher than what she has been presently drawing the salary in, on the ground of her having made value addition by way of BA, BP, and BPED, BPED qualification from the date of her initial joining, namely 3/12/2011. First one. The prayer in the representation, the prayer column in the representation reads as under. Next one. Learned counsel for the petitioner submits that the claim of her client is squarely covered by the decision of the coordinate bench in WPC 13112 of 2021 between Rajiv Kumar Sahu versus State of Odisha, disposed of on 19/2/2024, and therefore, in the light of observations therein, her client's representation ought to have been considered. First, she tells the court that in the absence of intervention of the court, representations of the kind would not see the light of the day at the hands of the officials. First. Next. Learned ASC Mr. Sin, upon request given for the rupees, in all fairness, agrees to instruct OP number 3 to look into the grievance of the petitioner, as has been held in the subject representation, which also mentions the decision of coordinate bench. If all contentions are kept open and a reasonable period is spent. First, with this proposal, counsel for the petitioner is agreed. Next paragraph. 6 weeks. Open to solicit information, etc. Next.
Item 38. 38, madam, challenging annexure 9, the rejection to anticipation of regularization. Similar matter, issue notice, madam.
Issue notice, call along with the briefing. ASC such notice for.
Item 39.
May I please, your lordship? Already, petitioner seeking the second and third RSCP.
Saraswati Boi.
My lordship. Accordingly, my representation is pending before the OP2, and that may be.
Petitioner's representation is 2/5/2024. Seeks sanctioning of second RSCP, third RSCP into bracket MACP with effect from 1/1/2013 and 1/4/2016 respectively, keeping in view the observations of the coordinate bench of this court in state of Odisha, division bench decision.
My lord.
Division bench decision of this court in state of Odisha versus Saraswati Boi in WPC number 7581. How it is WPC? Should you?
My lord, WPC number 7281
of 2018
and WPC number 4848 of 2021.
4848 of 2020.
Order dated 24th June.
Disposed of on 24/6/2022. First. Learned DSC appearing for the OPs in all fairness submits that he would instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation. Should all contentions be kept open and a reasonable period be prescribed. First of all, this is fair. Placed for 8 weeks. Similar.
Minor, similar role. Obliged.
Item 14.
Item 40, Your Lordships. Your Lordships, the petitioner's late husband, late Bhagwan Acharya, he was the denial of the grant of UGC scale of pay to the deceased is the main
Of pension on that basis.
Yes, Your Lordship.
Take notice.
Grateful, Your Lordship.
Emergent notice. AG is requested to accept notice for 1 and 2. The emergent Mr. Body learned DST is requested to accept notice for 3. Emergent notice.
Your Lordships.
Union of India.
Yes,
Your Lordships.
Notice for 3.
Your Lordships, just one submission. The deceased has been appointed prior to the cutoff date of 1/1/1986.
I saw that. Emergent notice to 4 and 5.
Grateful, Your Lordship.
Item 41.
May I please, my lord?
Yes.
This is prayer for a direction to the opposite parties to carry out the order passed by the tribunal and confirmed by this honorable court, my lord.
Tribunal waiting,
my lord. That has got merged with this honorable court, so therefore the execution has to be.
Yes, sir. Why are you not implementing writ of the court?
I will take it social plan some time then.
Show emergent notice. The DSC is requested to accept notice for all the OPs. Matter pertains to implementation of writ of the court, which affirms the order of the OAT. Thus lies in a narrow compass. Call this matter week after next for reporting compliance, hopefully. Otherwise, I'll direct the officers to be personally present before the court and ask them to sit on the last bench. Yes. Till evening. Yeah.
Yes, my lord, the AGT scale of pay, my lord has not been given. My lordship order is there.
Yes. Issue everything. This is request.
So I have fixed in the second week.
Call along with WP number 7.
Item 43.
Director of Secondary Education notice has to go.
Yes. My lord, I am giving you all this copy.
Notice to Director of Secondary.
I have all except OP number 5.
OP number 5. You appear for rest of the people. Rest of the notice to OP number.
My lord, the petitioner, while continuing as a reader in Sanskrit, and was superannuated from his post on 28th of February 2025, and was enjoying the provisional pension, my lord, a proceeding was initiated against the petitioner under Section 7D of the Orissa Education Act. 7D, my lord.
What is that?
7D is, my lord, your lordship will kindly get it at page. Recovery of grant in aid from the institution at page 141.
From the institution?
Yes, ma'am. That has been settled by this court in the coordinate bench that any proceeding under 7D is to be initiated against the institution, not against any person.
Individual.
I have been continuing. I was appointed in the year 1990. Then, my lord,
they want to recover it from you.
Well, they have decided to recover it from me after I was superannuated, my lord. And that the government has rejected a process. They asked me explanation. I gave the explanation. Now they have rejected it. Now they are going to stop my provisional pension also. Your lordship can have looked the law that the coordinate bench has decided
let's say he has been provided an opportunity ballot.
The opportunity, all right. Where is the power? Giving opportunity of hearing and then shooting is meaningless. Your ground that we have heard him before shooting is no justice. The recovery is to be from the institutions. Very section says that. That's what. Give that section.
141 of the.
So individual is not the focal point of 7D.
Yes, ma'am. That's it.
Issue. First time it has come?
Yes, first time it has come.
Issue emergent notice. Stay of refused order till next date of. This interim protection is granted after scanning the provisions of section 7D of the Orissa Education Act 1969, which textually focuses the institution and not the individuals who worked therein, more particularly those who have been superannuated.
My lord, this order is to be in IA number 2116.
Yes.
Yes.
Order on. Okay.
Item 44. In this case, I have limited grievance reproduction that I have applied for certified
copy of entire case record.
My lord, in remand revision case, my lord. But that not is applied to me.
Next time, bring the copies. Entire file here. With Xerox and give him. Each case is requested to accept notice. Call this matter next week. Case is directed to keep the original file present before the court on the next date of hearing.
2000 record, my lord. 2000 record, my lord. 25 years back, my lord.
Correct.
That might have been some more
time. Assume like that. Suppose if the records are there, then we'll bring it. If the records are not there, give endorsement saying that this one. Then he will go for a rebuilding of the records. There are other ways as to when records are lost, what should be done. It's spoken by the apex court.
Yes, ma'am.
Yes.
Item 45.
This man has already heard identical matters. This petition of pay, yes. In the advance is granted. Retirement. There are other judgments also, my lord. I can.
Same order.
Same order. There are another 4 or 5 judgments which cover me.
We don't weigh the number of judgments. One judgment. But it is not like where Shakespeare said, of course, it is ascribed to Aristotle also. One swallow makes not the summer. One sparrow makes not the summer. That is not applicable here. One judgment will do. Let's hold on.
Item 46.
Yeah.
Petitioner is challenging the inaction of the opposite party number. Human not considering the application. Petitioner is challenging the inaction of opposite party not considering my application on the rehabilitation assistance scheme, my lord.
You applied on 12/1/2024.
Yes,
when the
sir.
death had occurred.
Death, my lord, petitioner's father died in the year 1883. 1883, my lord. He applied in 2013 and his application was assessment before the opposite parties. In the year 2020, the assessment scrutinized my application and without any approval, they kept pending since long.
But death happened in 1983.
Yes, my lord.
How much money terminal benefits family got?
No, my lord, no.
Huh?
No benefit given.
Where have you stated in the petition? Where have you stated? What was he?
He was appointed as headmaster, my lord.
Headmaster.
Yes, my lord.
So he died in harness
Yes.
or after retirement?
My lord, during service.
During service in 1983.
Yes, my lord.
What is the amount terminal benefits the widow and children got?
No amount.
Now, where have you stated in your petition? You're orally only you are saying. And after 1983, 93, 2000.
Paragraph 12. Paragraph 12, my lord. In the case of petitioner, neither any financial benefit has been extended, nor his case was considered to be appointed under rehabilitation assistance scheme. My representation is pending before.
No, representation is pending, but if I direct consideration, they may reject it. Or you
My serial, my lord, in assessments, my lord, in paragraph annexure 7, my lord, kindly see. My name was in the serial number 17. After scrutinized, my application, their assessment was done, and my name was there. The serial number 17. That is annexure 7, my lord, page 20.
You take a decision, brother? No. Petitioners, your son or daughter?
Son, my lord.
Petitioner's father was working as a headmaster, having died in harness in 1983. His claim for compassionate appointment appears to have been recommended. Recommended by whom? Who is the authority? Who issued this? You have shown that one. By some authorities in the department, as is reflected in the format. In that format you have shown to me.
Page 20, Annexure 7.
Annexure 7. First, counsel for the petitioner submits that though a representation has been given on 12/1/2024 as per Annexure A, nothing has been done towards granting rehabilitation assistance in terms of the statutory scheme. And therefore, intervention of this court is eminently warranted. Next one. Learned ASC appearing for the opposes the petition contending that rehabilitation scheme is conditional and therefore, as a matter of right, no compassionate appointment can be secured without complying with the conditions. First off, having so stated, he fairly agrees to instruct OP number 2, 3. Yaru.
OP number 3, my lord.
OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation, keeping in view the enlistment of the petitioner in Annexure 7. First off, this to be done within a period of 8 weeks. First, ordered accordingly, and writ petition is disposed of. Delay shall be viewed seriously.
Item 47.
Next.
My lord, the husband of the petitioner had died in 2002, leaving his old parents and 2 children and a wife also. And the wife is now aged 55 years of age, and she is requesting the competent authority, Jilla district collector, district education officers and others.
When
appoint.
When husband died?
2002, Your Honor.
2002. What was he?
Plus, it's school teacher in primary schools.
How much terminal benefits the widow got?
Sir, she has not received any terminal benefit.
Huh?
Not received, sir.
Not received. Where have you stated in the petition?
Sir, it is part 3, page 4. Lastly.
Pension and other things have not been given to you.
No, sir.
Huh?
No, sir.
No pension is given.
Not sure, my lord. In annexures, my lord, the representation is stating that he is getting pension, my lord. In page 23.
How much pension you are getting?
That is.
So I'm not sure.
Huh?
I'm not sure.
Lord, that he is not stated. And also not filed in documents to that effect, my lord.
Petitioner to state on affidavit as to the amount of terminal benefits she received on the death of her husband in harness, and also the amount of pension which she has been drawing as on this day, filling which petition runs the risk of dismissal. Call week after next. Okay.
Item 48.
Challenging the order under Annexure 1. The order under Annexure 1, where the opposite part number 1 has rejected my representation against stoppage of annual increment for the year 2021 to 2023. They say that since I availed the annual increment for having the PhD qualification, advance annual increment, so the day 3 years completes, they should be stopped. And accordingly, they have stopped my increment from 2021 to 23.
They have stopped
matters.
Did you make a representation?
Matters. I have made the representation, and in that representation, they have passed the order under Annexure 1.
Rejecting this.
Rejecting this.
Issue notice. Yes, accept complete for the vote, please. Yes, please. Okay.
Item 49.
My name is Your Lordship.
Yes.
My Lord, matter relating to transfer of schematic to primary school teachers. Covered by Your Lordship judgment.
Covered means which 5 parameters are fixed. In which parameter it falls?
My Lord, practitioner was working as S card of primary school teacher. Is transferred to from RCUP school under block Pankadahar block to Pojang block. Next cadre teachers and schematic teachers are not transferred, cannot be transferred as per the guideline. Last para minute judgment is clear that it will be applicable onto the person who can continue schematic and ex cadre course, not regular cadre teachers.
This appears to be covered by the judgment. The subject matter of this petition is substantially similar to the one in WBC 23269 of 2025 between Sanishcha Ranjana Behera versus State of Odisha. This word of by this court, by order dated 24/11/2025. Wherein paragraphs 4 and 5 of the petition of the order, above order, read as under. First one. Next one. In the above circumstances, this petition is also disposed of, granting the same relief as has been granted to petitioners in the cognate case, mutatis mutandis. Yes.
Item 50.
Yes.
It's a leave of your lordship. This is relating to cancellation of the plot on the basis cancellation of allotment of the plot on the basis of wrong submission or affidavit filed by the transfer.
that Mishra case. Sushma Mishra.
Sushma Mishra's case. My impugned order is before your lordships at page 47, Annex 6, dated 21/8/2025.
Issue emergent notice. The DG is requested to accept notice for one. Emergent notice to the rest. First, petitioner draws attention of the court to IA number 21324 of 2025, supported by an affidavit seeking grant of reprieve. First, counsel cites edition of this court in Sushmita Mishra.
Sushma Mishra case.
Do you have that copy?
Yes, I have got a copy, and it is also reported. Your lordship may. That is 2025, volume 2 OLR.
2025, volume 2 OLR.
Page 699.
699. And draws clarity with the fact matrix of that case. First off, there is prima facie case made out for grant of interim relief. First off, in the above circumstances, application having been favored, there shall be interim stay of impugned order dated 21/8/2025 at Annexure 6. Next paragraph. Since this interim order is granted ex parte, the opponents, answering opponents, it is open to them to seek its variation or rescinding if grounds do exist therefore. Or grateful.
Item 51.
The private opposite party is there, notice also.
Notice.
I'm grateful.
May I please, Your Lordship?
Yes.
This matter relates to change of designation. The petitioner was appointed as a science attendant, but the district education officer has treated him
watchman cum
sweeper. He has honored amongst 3 peons. His qualification is +2. So far as the person who has been designated as science attendant, his qualification is only class 10, class 9. I have made a representation to the district education officer. Let him consider and cause an inquiry.
Petition prayer reads as an counsel for the petitioner draws attention of the court to the representation dated
15/9/2025,
a copy whereof awaits at Annexure 7.
Yes.
Wherein a request is made to the district education officer to change his designation from night watchman cum sweeper to science attendant. By taking into account his educational qualification and the appointment order dated 14/3/2008 as well. First, counsel submits if a direction is issued to consider the subject representation, justice would be met to his client. First, next paragraph. Learned ASC Mr. Sen, on request appearing for the Odisha, fairly agrees with the proposal of the petitioner, and that he would instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way. First, however, he caveats that all contentions of the parties should be kept open. First, next paragraph. 8 weeks.
Item 52.
May I please, Your Lordship? In action of the opposite party number 3, for disposal of my representation regarding grant of first MSCP and second MSCP, and also some area dues. In the meantime, Your Lordship, I have made a representation to the government. Government had forwarded it to the opposite party number 3. Matter is pending before the opposite party number 3. So direction be given.
Short grievance of the petitioner is against inaction attributable to OP number 3, who has kept his representation dated 29/2024, wherein he has sought for
First MACP, second MACP.
First MACP and second MACP.
And some area due in respect to whom?
And arrears in that region. First up. Learned counsel for the petitioner submits that in similar matters, this court has given direction to consider representations of the kind, and therefore the same treatment should be meted out to his client as well on parity basis. First up, there is both submission. Next paragraph. Learned ASC appearing for the only one.
The DAV organization.
Submits that appearing for 1 and 2 submits that he would instruct OP number 2 to look into the 2 or 1
opposite but not 3 look into the
regional director DAV organization
3 OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation. First off, he also tells that a judgment of this court be sent to all the OPs by speed post for consideration. First off, this is fair. Next paragraph. The above circumstances. 8 weeks. Open to solicit. Registry to send copies to 3 to 7. By speed post immediately. Yes.
Item 53.
Challenging the order of punishment, I prefer an appeal matter by the annexure 4, which is still disposed.
Then appeal is pending.
Appeal is pending by the annexure 4.
Petitioner, having suffered a penalty in a disciplinary proceeding, has preferred a departmental appeal against the same. First, petitioner grieves that the said appeal has been kept pending for long and therefore a direction be issued to hear and dispose of the same within a reasonable time. Right to speedy remedy being consistent, being part of Article 21 of the Constitution. First, there is force in this submission. Next paragraph. In the above circumstances, OP number, which OP?
One minute, Chancellor.
OP number 1 is directed to hear and dispose of the appeal on merits within an outer limit of 3 weeks. First of all, contentions of the parties are kept open. Registry to send a copy of this order to OP numbers.
OP number 1 minutes.
To all the OPs.
No, only OP number 1. That Chancellor.
Only one OP.
Only one OP number 1 appeal is pending for the OP number 1.
Correct. But others should know what order I have passed. Na? Yes. Next.
Item 54.
Petitioner's criminal execution proceeding case is pending in the court since 2023, Your Lordship.
23?
Yes, Your Lordships. Criminal execution case.
With Rahul Shah. Do you have that copy?
No, Your Lordship.
Good. Short grievance of the petitioner is against the long pendency of the execution proceedings in the execution case number?
Execution case number, my lord.
Of 2023. Pending on the file of court.
JMFC Puri, Your Lordship.
JMFC, not civil court. JMFC is a magistrate court.
Domestic violence case passed under
JMFC.
Yes, Your Lordship.
Pending on the file of learned JMFC.
JMFC Puri, Your Lordships. Annexure 2 is the entire order.
JMFC dash POG Roman 2,
yes,
Puri. First. Learned counsel for the petitioner submits that the apex court in Rahul Shah versus so and so Gandhi. Jitendra Kumar Gandhi. 341 has observed that all execution proceedings should be accomplished within a period of 1 year from the date of their institution. And therefore, a direction be issued to the learned JMFC to accomplish the same. First off, there is force in this submission. Next part, in the above circumstances, learned JMFC's petition is disposed of, requesting learned JMFC to accomplish the execution proceedings within an outer limit of 8 months, and report compliance to the Registrar General of this court. First, while computing the period of 8 months, that the adjournment period taken by the petitioner shall be excluded. All contentions kept open. Registry to send copy. Any opposite parties?
Yes, Your Lordship.
Registry to send copy of this order to the OP by speed post. Yes.
And item 55, and the petitioner is challenging the inaction of the OP number 3 in carrying out the order of OP number 2, my lord.
OP number 2?
My lord, the petitioner filed an application for issuance of legal heir certificate, my lord. The OP number 3 refused to grant a certificate. Against that, I filed an appeal before the sub-collector, OP number 2. OP number 2 find that there were enough materials to grant legal heir certificate, so he remanded the matter back to the OP number 3 to rehear the matter after issuing notices, and the same exercise shall be undertaken within a 1 month period, my lord.
He has not done that.
He has not done that. After that, I filed a representation at Annex 5. But despite the representation, no action has been taken.
Legal heir certificates.
Legal heir certificate.
Proceedings relating to the claim for legal heir certificate having been terminated, were carried in appeal, and the appellate authority, having set aside the rejection order, remanded the matter to OP number 3 for consideration afresh, prescribing a period of 1 month for accomplishing the task. First one. Next paragraph. That counsel for the petitioner submits that though months have elapsed, nothing has been done in the matter, and therefore a direction be issued to OP number 3 to accomplish the proceedings on a war foot. First off, there is pause in this submission. Next up, in the above circumstances, this petition is disposed of, directing OP number 3 to accomplish the remanded matter within an outer limit of 1 month reckoned from this day, failing which his personal presence may be directed before this court on an appropriate application being made. First off, all contentions kept open. You have registered to send copy of this order by speed post to all the OPs. OPs 2, 3, 4. Mr. Behura appears for appears for 1, 2, 3. Registered to send copy to 4. Okay.
Item 56.
Present petition is challenging the notice under Annex 2, which has been issued by the opposite party number 3 in connection with the vigilance case where the petitioner had not the party to that criminal case, my lord.
Notice is what?
Notice with regard to open up the locker, my lord, under 94 BNSS, my lord.
94 BNSC.
BNSS.
BNSS.
Yes, my lord.
Read section 94. You. Our own papers, our own book, and your own money. Yes. Does it give power to open up?
No, my lord. Present petitioners, they are no way connected to
how we will know? Every criminal will say, I am not nothing to do with that.
I am not a criminal. Because we are the relation of the engineer.
Correct.
Yes.
If stolen goods are kept in your locker, is it not open to the police to verify?
This is my personal property. Once it will be open, your lordship can visualize. Once it will be opened, or whatever materials I have, that will be taken by the police. And it will not be identified which property of the petitioner or which entire property will be seized by the police. Thereby the petitioners will be harassed. Here,
no. That is on the assumption that everything belongs to you and it has nothing to do with
it. My proportional property, my lord.
No, that's what you are saying.
Yes.
That's what you are saying.
Yes.
Do you have, what all properties you have kept inside the locker? Do you have any receipt for having bought them?
Yes, they have not. They have not directed to produce the list of the.
No, I want to know.
No, they have not. I will produce my.
You show that.
Yes.
Otherwise, I will appoint 2 advocates to be present for the court.
Yes.
When
I'll take instruction in that.
Call next week at the request. Yes.
Item 57.
Yes, please.
Somebody is challenging the inaction of OP. That is similar matter to 46, item 46, my lord.
46.
Yes, my lord. Here the petitioner's father was PET.
The subject matter of this petition is substantially similar to the one in WB number 34503 of 2025, wherein a direction has been considered to expedite the consideration of claim for compassionate appointment under the rehabilitation scheme. First off, in view of the above, the petition is disposed of with the same direction as has been issued in the cognate petition. Okay, next.
Item 58.
Hello, you'll also try to come to the Annexure 7, page 13. The person retired from service on attending superannuation on 31st/10/2025. Almost 2 months have lapsed.
Pension is not paid.
Not yet. My even pension paper has not been sent to Office of Accountant General. I put in around.
You take emergent notice, Mr. Behura.
Well,
till next date, issue emergent notice. Mr. Behura is requested to accept notice. The immediately Behura is requested to notice for your peace. All matters pertains to the claim for pension of a retired employee. Come on. The jurisdictional authority shall expeditiously take the steps in the meanwhile, so that no heavy costs are levied on the next date of hearing. What?
Last week.
Huh?
December last week. Maybe.
No, it was from first week of December.
All other state are repenting all that opposite parties are concerned 1 to 5. All are repented by the state. Can I permit it to serve extra copy or as your lordship suggest?
Let you extra copies also.
As your lordship. Much obliged. You'll also last opinion with that Tina Gupta for the state of Kerala case.
Correct.
Kerala, so for pension is released. Release of pension is concerned. It is not a boundary that.
Not Tina Gupta.
And as on date.
Yes, Nakara versus.
And as on date of retirement.
About privacy of a lady.
Yeah.
Privacy. Next.
Item 59.
Petitioner, husband of the petitioner while working as PT under aided educational institution died in harness on 2009. Living behind is petitioner and 1-year-old child. And the opposite number headmaster and appointment he has.
What happened now?
So he is for compassionate appointment, paid for his compassionate appointment. The
rejected or
rejected.
Issue notice. CG requested for some notice for our peace. Next.
Item 60.
May I please, your lordship? I am in VC, my lord.
Yes.
Yes, my lord. My lord, the petitioner selected as a CORAM attendant, my lord. That is on by the Annexure 3 on dated 30/2025. But the OP number 3, District Welfare Officer deployed the OP number 5 to an outsourcing agency, my lord, which is in violation of the guideline as well as the selection process, my lord. I was selected as a CORAM attendant as per following the due process of law and the process selection process. But the OP number 3, my lord, deployed an outsourcing agency, that is Annexure 4, my lord, page 29.
50 Behera.
My lord. Tripati Behera. I was, my lord, as per advertisement by the Annexure 1, as per advertisement by the Annexure 1, I have applied for the post of CORAM attendant. With the requisite documents, my lord. A meeting was held on 30/2025 for selection of the post of CORAM attendant. In presence of the school managing committee, WO, chairman of school managing committee, headmaster of Butawada Primary School, 2 assistant teachers, the Hon'Ble workers, and other parents. in accordance with the permission of the district welfare officer, that is letter number so dated 21/7/2025. The said committee properly scrutinized and verified the documents submitted by this present petitioner and selected as COCOM attendant on 30/8/2025. That is Annexure 3, my lord. That is ODI Annexure, my lord. Page 26, my lord. ODI, that is ODI. But the OP number 3, district welfare officer deployed the OP number 5 as COCOM attendant from an outsourcing agency, that is Grow Best Multiple Service Private Limited.
Why outsourcing? Our own people are there. Why should not be taken? After all, a cook.
It seems his selection was conditional, subject to giving some certificates, moral certificates.
But generally, our local people should be.
The person employed also local.
Other agency. Local only, but through other agency, where agency will extract its
Take instruction manual for it.
Issue emergent notice. There are such notice for OPs. Emergent notice to file. All right, I'll come back. I'll come back after. Thank you. Any urgency, Mishra?
No, I don't. Now that I am very to organize such an event, it takes a lot of time. I would 67 matter, a small matter there.
67.
67. That is very small matter. Yes. Actually, now that time is running out. Time is running out. So I have to make a lot of arrangements.
No, but in that 67. Yes, what is the matter?
Well, the matter is that the petitioner is working as assistant professor in Orissa University of Agriculture and Training. She was the junior employee, but there was a ICR, Indian Council of Eco Research. Many projects have been conducted by ICR, and OUT is the authority to do the project work. And the project in charge is representing the ICR project for project development work in the project review work in ICR. Not every year, but she was though she was not eligible, but she was sent by the project OUT. ICR clearly said that no, she is not eligible, she cannot come. That I have intimated to the authority, but authority again sent me. But the project was closed by ICR. Now charge sheet has been submitted against me, and that because of you, project has been submitted. But charge sheet is. I asked for this. She is not feeling well. I think. So the charge sheet after I got the charges, I asked for the documents. They didn't supply the documents. Now they have appointed the inquiry officer. Without supplying documents, how can I submit
notice? Learned senior advocate Mr. appearing for the petitioner presses the application in IA number so supported by affidavit. He also quotes caution of the Dixit versus Pickout. So in support of his contention that in the absence of furnishing, without furnishing the copies of documents, the inquiry proceedings cannot go on. Kashinatha Dikshitalu versus Union of India. So which is the citation? First off, a prima facie case is made out for grant of interim relief. First off, in the above circumstances, application having been favored, the proceedings in question are interdicted till the next date of hearing.
Annexure 12. Annexure 12. That is
the proceedings in terms of Annexure 12 are interdicted till next date of hearing.
Much obliged.
Yesterday I could not go through the file because of that net. Immediately after.
Only one thing, your worship directed in the last occasion.
Yes, records.
We have produced our record.
We have produced it.
Only government record has to be produced, failing which may not 25,000 penalty. And unless that record produced, it will be difficult to proceed the matter.
Yes, Mr. G, who appears for the government.
This matter is with Mr. Mahanti. 94. Item number 94 is with Mr. Mahanti. Some instructions has come.
The tribunal's record is to come.
Some instruction he has received.
Tribunal record and director's record.
I was told that.
Have it immediately after.
My lord.
Call this matter and in the second week of January 2026 at the request of all.
May I mention, madam? I don't know. I pray.
Second week, you should fix a date, because I'm not getting salary for last 1 year. What is that?
January, I'll complete that.
Yes.
Time, I'll complete that.
But let them produce the record today.
If they have
He has said that he has got the record.
ordered to produce records to be complied with by the government.
Interim order to continue, madam.
Interim order to continue till next date. Yes. Okay.
Maybe to mention, madam. Item 98 may be taken up because I have been deprived of filing online application where the similarly situated persons document verification has been made. So I will be prejudiced.
When it is, the document verification is.
Document verification was, the order was made on 6/12/2025 and it would be conducted from 12/12/2025 to 24/12/2025.
Please wait, let us see. Many matters are already disposed of and adjourned. Let us see. Yes.
Item 61.
These are pension matters. Yesterday, before your lordship, I'm handling. This may be tagged with this family pension and pension matters under Equal University.
Third week of January. Yes.
Yes, please. Date full mail.
Item 62.
But the petitioner's institution got temporary recognition from the academic session 2005-2006. And temporary recognition was extended from time to time, from year to year.
He has to take a final decision in the matter.
That is, my lord, I have prayed for antedating permanent recognition from 2005-2006 because we have fulfilled
instead of 2012-13.
13, yes.
Let them take a decision.
Petition
prayer. He reads as that. Next paragraph. That counsel appearing for the petitioner draws attention of the court to the petitioner's representation dated.
That is 2020.
A copy whereof awaits at Annexure A5, wherein the last paragraph reads as that. Yes. Next paragraph. That counsel for the petitioner submits that if a direction is issued to
OP number
3 to take a call on the subject representation, his client will be satisfied. First, with this proposal, learned AGA Mr. Behura is also agreeable, subject to the condition that all contention should be kept open and a reasonable period be granted. First off, next fact. In the above circumstances, 8 weeks. Okay.
Item 63.
The execution custody annex of 14 is pending before the learned State Educational Tribunal. He has superannuated from his service from 2022. He was a lecturer. My lord. He prepared your prayer. We issue notice to opposite parties.
That itself is a prayer. That I will do even if you do not pray. But what is your complaint?
Consider the grievances of the petitioner.
What is that grievance?
Grievance is, my lord, the execution proceeding is pending.
Where is that?
Annexure 14, my lord.
1/4, my lord.
Yes, 38.
Before the State Educational Tribunal.
My lord,
But the petitioner's essential grievance is against long pendency of execution petition number
13 of
2021, arising from GIA case number 172 of 2015, disposed of on 5/7/2018. First. Next paragraph. Learned counsel for the petitioner submits that the apex court in Rahul Shah versus so and so 2021 Supreme Court has held that all execution proceedings in the country should be accomplished within an outer limit of 1 year from the date of their institution. First off, this would apply to the execution petitions of the kind as well, inasmuch as right to speedy justice is a facet of Article 21. First off, in the above circumstances, the tribunal is requested to try and dispose of the execution proceeding within an outer limit of 6 months. All contentions are kept open. Next, while computing this period, the adjournment taken by the petitioner shall be excluded. Okay.
Item 64.
In this case, the present petitioner through farmers, they could not register through online process for procurement of paddy. Therefore, they, like the petitioner, some other farmers also could not register due to online difficulties. They made an application before the collector under Annexure 1 to accept the offline form so that they can give the paddies to through the procurement policy. That is
policy is
online
specific.
Online.
Because the online in rural area, they face the difficulty in submitting the application. Therefore, they
that will create problems, my lord.
Therefore, just look into it.
For transparency.
If online
glitch or any problem, he has to show that we tried and we failed.
Therefore, just look into that and come back. I'll issue notice. If Mr. Behera is requested to accept notice for OPs.
5 up to 5.
1 to 5.
6 and 7.
6 and 7.
6 and 7 only may be dispensed with for the timing because they are only the society to whom will submit.
In fact, this is done by civil proprietor person.
Registration.
Item 65.
The short date will be because they have.
Yes, short date I have given. Yes.
The petitioner, the education volunteers paying for a direction for release of the real salary of the petitioner minor from 24/10 to 23/11 minor.
That is rejected now.
No, my lord, minor. They have rejected on the ground. They are rejected and they have also minor time page 17.
No, let notice go because rejection has happened now. That needs to be examined. Let notice go.
Yes, ma'am.
Request accept notice for OPs. Next.
Item 66, 67 has been disposed of. Item 68.
These are regulation matter. In the similar matter, notice already issued, my lord. Not these are the.
Issue notice, call along.
My lord, only I can. My lord, no date has been mentioned. Only that may be mentioned.
Yes. Call along.
Item 69.
And I'm challenging Annexure 4, my lord. Page 19, in where my PhD registration has been deregistered. The PhD registration was cancelled. My lord, though the fault was mine, my lord, I did not continue the PhD process within the period. But I have made an application for its continuance, which is under Annexure 5, which is pending before the controller. The Lordship may direct to consider, my lord.
Take notice.
My lord.
I want to hear them and then I will pass order.
Yes, my lord. The notice will go to 2, 3.
Behera for 1, 2, 3, 4 notice. Remember that notice.
Item 70.
Item 70 another can it next week,
What adjournment?
No.
First week of January. Second week of on 5th.
Lordship, I am appearing for the OP4. Today, just Lordship, I filed a wakalatnama.
In?
Lordship, this case in item 70.
Yes.
Lordship.
Sorry. So
Item 70.
Sorry.
Receipt of that.
Next.
Item 71.
My lord. Lordship, a similar matter, your Lordship already passed an order. Day before yesterday, your Lordship asked me.
Identical matter.
Analogous case is second case is there. Same case, ma'am.
Item 72.
72 also is covered by Saraswati Boy case. Your Lordship also passed similar order.
Sir,
All connected by same manner.
All connected.
Item 73.
73, 79, 2025. Coordinate bench period has asked the government to take instruction of whether that judgment case is covered by your lordship judgment seeking writ appeal. But that was given as annexure is 11, page 61.
My lord, 73.
So many allies are sitting there.
73, my lords, will file counter in this case.
Well, in the second week of January at the request of.
It's already covered by your lordship's order. And it's 11.
Let us. Yeah.
Item 74.
74, my lord, petitioner was engaged as a Ganashikya from 3rd of May 2008, my lord. His prayer for regularization, he was regularized in 2017. He prayed for regularization with effect on
2014,
my lord. Now they regularized the service of the petitioner with effect from 2014. But while extending the benefit, they said notionally. My lord, have already issued notice similar matter, my lord.
Issue notice. Call along with WB.
Item 75.
Your Lordship, the petitioner is a differently able person. I filed the disability certificate that is annexed 5, Lordship. Here the grievance of the petition has been filed by the collector, district magistrate to the Tahsildar Patrapur, but the Tahsildar Patrapur did take any action pursuant to the grievance filed by the petitioner.
What is that?
The grievance of the petitioner that the land of the some portion of the land will settle in the disability quota in favor of the petitioner. The petitioner is a landless person residing in the government land since 20 years back by constructing by allotting Indira Awas Yojana. By allotting the Indira Awas Yojana, but till that the land has not been settled in favor of the petitioner. The petition moved to the district to the Tahsildar concern, thereafter to the district magistrate. The district magistrate forwarded to the grievance of the petitioner to dispose of to consider the grievance of the petitioner, but till that no consider.
What is the grievance?
Grievance, Lordship, the Annex 16 is my grievance, that is Annex 8. Annex 8 is only page 16. The letter has been communicated by the district magistrate that is Annex 7 only page 15 to the Tahsildar, Lordship.
Read Annex 8.
Annex 8, Lordship.
Read and translate it into English.
Annex 8 is a representation.
Saying?
It is saying that he is a physically handicapped person. He has no house. So and so more my family and others are living separately. I have no house of my own. There is a OPLE case registered against me.
OPLE case means?
OPL
2002.
What is that?
OPL
Land encroachment. Prevention of
land encroachment case. OPL case was
it is under the which act?
It is itself Orissa Prevention of Land Encroachment Act.
itself is there. There is a case was registered because he has encroached a public premises.
Yeah.
That's why he wanted that the land should be settled in his favor because he is
Because he has encroached.
Yes, because he is differently abled.
No,
His family,
differently abled. If he encroaches,
Presently, government have also taken this in the person those who have no landed property.
Where is the law?
Yes.
You may be a disabled person.
Yes. His family members are having landed properties.
Your family members are having landed property.
But no land in favor of the petitioner. In the definition of the family, considering the definition of family, the land has been, the Indira Awas has been allotted to the petitioner, Lordship. The petitioner has constructed the house.
It is allotted to you.
Lordship. Construct the house and
let them consider, dispose of this OPLE number 18 of 20.
181 of 2002.
2002. Let them complete it within 6 months.
Lordship.
In accordance with law.
Lordship.
Petition prayer though is vague, the vagueness can be overcome by seeing the contents of Annexure A, which reads which are as under. First off, the learned counsel for the petitioner submits that his client happens to be a differently abled person and that he has put up construction on the alleged encroached area, which he says that it has been allotted to him under a particular scheme. Full stop. He also tells the court that OPLE case number 181 of 2002 is still pending. And therefore, if a direction is given to hear and dispose of the same, that would mete out justice to his client. First, the AGA appearing for the OPs is agreeable with the proposal of the petitioner. First off, in the above circumstances, the jurisdictional authority shall accomplish the proceedings in the subject OPLE case within a period of 6 months. All contentions of the parties are kept open. First off, it is open to the petitioner to take up all defenses that are available to him on account of his physical disability by vouching the same. Next.
Till then I may be protected. Till then I may be protected. I may not be disturbed from the land.
Till a final decision is taken, we shall not be disturbed from the occupation of the house in question. First.
Items 76, 77 have been adjourned. Item 78.
Is also adjourned, na? 78, 79 are adjourned. 8 is disposed of.
81.
81. Yes.
On behalf of Mr. Devan and Mr. Milot, here the demonstrator claiming for UGC scale of pay Milot and earlier approached the Honorable Court and its Honorable Court directed to consider the representation, and that has been rejected by the authority. And this year your lordship already similar matter and issue notice to the
sure. Please. Go to the first thing. No. ESG, the body is requested to accept notice for 1, emergent notice to 2, AGA for 3 and 4. Yes, call along WP number.
Item 82 has been adjourned. Item 83.
Your Lordships, a batch of cases were there before my lord. in which your lordship can look to page 21.
Page
21. Where an order was passed directing that all the termination orders have been passed, and one of them, my lords, after that they did not allow. Your lordship have passed one order. This same order is governed because that is all batch of cases.
Same order.
Same order.
Issue number 26. Submit DG request to accept notice for 1, 2, and 3.
My lord.
GA is for 1 and 2. Emergent notice to 3 and 4.
Yes, sir. 2 and 3.
1 and 2, 3 for notice.
3 for notice.
Next one.
Hello, sir. Three that matters have been let out from this group. I'm giving a list. That can be. Same order be passed, 3 matters have left out. The list. That should be, will it come in the list or you
will get them here? Can you get them today or tomorrow? Tomorrow. The counsel for the petitioner submits that. Already, in a few matters, this court has granted interim relief for it order dated 20 August 2025. And then similar relief should be extended to the petitioner who all have moved and application supported by applicant.
I've prepared a list, minus that. I'm handing over the list of these matters, leftover matters, that out of line, one order has been found that is to be repeated.
There is for service submission. In the above circumstances, the 28-2025, the same the relevant part of the same reads as under series. In the above circumstances, the interim relief granted in the cognate matter is extended to these petitioners as well. First, all applications are disposed. Accordingly, the applications are disposed. Okay.
Item 84.
Right, please, your lordship, my lord. So far, item 84 is concerned, for an on behalf of the Jageshwara Mishra, defendant number 5 of the trial court, decree bearing number 66 of 2008, I have filed an improvement application, my lord. We have to solve a copy of the Lord and Counsel for the petitioner, my lord.
No, you are for the my lord, I am for the. Since it is a matter of 2016, my lord was pleased to consider my mentioning it. It was listed in the weekly list before vacation. Your lordship, I can see 2 lines. I will just though it is listed for others, I have no grievance if anybody is added as a party. Regarding that, though copy has not been solved. Your lordship, I kindly say the administrative inquiry conducted by the district judge, and the result thereof being communicated to me in a cryptic manner that your grievance is dismissed in violation, inquiry conducted in violation of natural justice. Though what was the inquiry about? Is my grievance is, my lord, I was allotted with a plot and the other side was allotted with a plot in the final decree. While granting the certified and during allotment, my lord, my petitioner noted the plot number. When the report was submitted by the lawyer of trial court had noted the number. When the certified copy was granted, it was discrepant. And in the naked eye, it is seen that the office, while issuing the certified copy, judicial with thereafter certified has been granted. I am holding the certified copy and the record has been called for pursuant to the judicial order earlier passed. My lord, my valuable land and nearer to my
But this matter requires due consideration after my health is restored.
Good. One thing, Prime Minister, I am giving to you, Lordship, though it is orders with the permission of the Honorable Court, I will just submitting. Your Lordship may kindly see. I could not hear. I could not. So kindly, date kindly fix. Otherwise, it not come.
In the second week of January, we will take.
No, melody is wrong. Sing 16. No, it is pending.
Only thing is, my bacteria and virus are not under my control.
No, no. I would go. Next week, let it come again. If it is urgent because of my lord's murder, I have nothing to say. Because land is with their possession, record is with them, they are selling. Anything can be done. So many things.
Are you selling the property?
No.
Selling the property.
Proceeding pending, my lord.
The subject property shall not be alienated or encumbered during the pendency of the petition. First, this order is made taking into account the special circumstances of the case, since urgency is pleaded for hearing of the matter when the health of the presiding officer is not that good. For this matter, second week of January 20.
Date.
Second week. Second week it will come. It will come before me only. Hopefully.
Date, it is not an inconvenient date for you.
Second week. 13, 14.
I am much obliged, man.
Item 85.
May it please your lordship, this is an application for restoration of a case which was dismissed for non-prosecution due to non-attendance of the counsel, was unfortunately gone to outside Orissa for his eye treatment and could not attend. And in a similar case, within that ill-fated spell of time, another case also here, and order has been issued by this report.
We have restoration. Why dismissed? So many cases are available for disposal.
Actually, 4 cases within that spell of time was actually dismissed.
The subject matter of this application is substantially similar to the one in this. Wherein this court, while order dated 10/11/2025, has observed as under. Next, applying the rule of equality, what applies to who would apply to tender, and therefore the dismissal order dated, which is that date?
17/6/2025,
made by a coordinate judge of this court is hereby recalled, and as a consequence, the main matter is restored to the court.
235 is also same. 235.
No, Lordship may detect.
Which is?
235, CMFL 235.
Sub-items.
239 is
sub-item. Same order. Date of dismissal is same.
Same.
We should not dismiss for default. When so many matters are there for taking up, why to dismiss the matter? Unnecessary, I do not know. Yes.
Item 86.
Item 86, Lordship, can file the IA for the change of name and address of the OP number 3, which was wrongly typed as a controller of examination principal secretary of Home.
Application seeks the amendment of the cost title to accord the factuals. First, no prejudice will be caused to anyone if application is allowed. First, in the above circumstances, application having been allowed, leave is accorded to amend the cost title as sought for. Next.
Item 87.
Item 87, may I please, Your Lordship?
Yes.
Your Lordship, I'm challenging the order of recovery, Your Lordship. On the last occasion, inadvertently, Your Lordship, the impugned order was annexed, was not annexed, and some other order was annexed. Hence, I filed an IA for amendment of the same, and I have filed the IA for adding of the impugned order, Your Lordship.
We can't withdraw this and file a fresh petition instead of all this confusion. I'll permit you.
With the permission of Your Lordship, I may.
petitioner seeks amendment to the petition, and she wants to produce some other order for being challenged. First off, in the fitness of things, if leave is accorded to the petitioner to file a fresh petition, justice will be caused to everyone. First off. Next part. With the above observations, petition is disposed of, granting liberty to file a fresh petition on the same cause of action. First of all, contentions are kept open.
Blessed your lordship.
Item 88.
May it with your lordships. In this case, my lord, in the order dated, my lord, 31st of October, so it is the OP number 4, my lord, is the competent authority. So instead of OP number 4, it is reflected the tribunal, my lord, education tribunal. It should be OP4.
In the order dated 31/10/2025, wrongly, tribunal has been mentioned instead of OP number 4, submits learned senior advocate appearing for the petitioner. First up. Wherever the word tribunal occurs in the subject order, the same shall be meant. The same shall mean OP number 4. And accordingly, the order shall be constituted.
Oh, blessed one.
Next.
Item 89.
The disposal date is 30/10/2025. Inadvertently mentioned 16/10/25.
Learned counsel for the petitioner points out that this matter was disposed of on 30/10 October 2025, whereas the order wrongly mentioned 16/10/2025, and therefore the same needs to be rectified. First off, there is logic in the submission. First off, registry to rectify the defect and issue a free copy of if applied. Next.
Item 90.
Legal. I filed application, writ application challenging the order of the collector. And after hearing your lordship's issue notice and stayed operation of the collector's order dated 12/9/2025 by order dated 11/11/2025. But in the order of the collector has directed Tahsildar to pass a certificate. By administrative capacity, knowing very well that the order has been passed, the antedated, the certificate is issued by the Tahsildar. For that purpose, I am filing this application with the certificate issued by the Tahsildar. That is Annex of 5. That is my application, IA number 20963.
You want to amend the cost title?
I mean that certificate which has been issued by the Tahsildar.
I do not know. Your prayer I am reading.
Two things I have prayed, my lord. Well, because since the Tahsildar was not made party, for that purpose I am...
You want to make him a party?
And thereafter the stay of operation of the certificate may be inoperative till.
Two applications you have filed.
No, one application I filed.
One application for implement.
Implement and the non-application, the non-operation of the...
How? Under your rules, for every prayer there should be separate application. Although one affidavit will do.
That I will be allowed to correct.
I will allow the first application. You implement Tahsildar. And then I permit you to make another application for stay of the order. Then we will consider that. Otherwise, it cannot be considered that way. Under your rules, which I establish.
Yes, ma'am. Let it come tomorrow. I will file an application.
This application I will allow now.
Yes, ma'am. Tomorrow.
Application support in IA number so and so supported by the affidavit. Seeks implement of the Tahsildar of Kandhamal.
Record is not there.
As OP number 4.
Personal conversation.
First, no prejudice will be caused to the other side if implement is allowed, in as much as his order dated 27/10/2025 is also sought to be challenged. First, next one, in the above circumstances, the application having been favored, petitioner is granted leave to implead the Tahsildar as OP number 4 to the petition. First, liberty is reserved to the petitioner to move an appropriate application for a reprieve against the certificate issued on 27/10/2025. If grounds do exist, therefore.
Tomorrow, let it come tomorrow.
Not tomorrow. In the next.
The application may be stopped because
you copy also.
He has not added the government officials.
The stay order passed by your lordships, the staying operation of the collector also has no meaning, my lord. That is infectious, but the collector, when the collector has been stayed, the Twelve issued the certificate.
No, unless there is an application. How the court can do? What else you say is true.
Yes,
what all I say is also true.
My intention is that of stay operation is considered and
day after. A day after. Yes. Next.
Let it come fresh on the fresh admission.
Yes. In the fresh admission first.
Item 91.
91 will withdraw. 91 withdraw. Yes.
Memo already filed. This code of has been withdrawn. Yes.
Item 92 has been disposed of. Item 93.
93 ka.
Item 93.
93. What is this matter? 93.
93 with humility, your lordship. I have misplaced the file. If you will permit, I will take the file to pen drive so that I can place the matter with proper perspective. And for your lordship's kind convenience, I will also make a note of submission.
I am occupied. We have filed the written note of argument. Which is citation.
This is that recruitment.
Several
recruitment matter.
The last
we have complied your lordship direction. While complying your lordship's direction, some persons were out of service. Those who are out of service, they have preferred this case.
Okay. Well, in the third week of January 2025.
And they are continuing in service.
They are continuing in service.
Very.
Okay. Entry orders are there?
No,
Interim orders, if any, shall continue.
Liberty
Registry to furnish e-file to counsel for the petitioner if applied for box.
Item 94 has been adjourned. Item 95.
Item 95, I appear for the opposite parties number 6 and 7 through VC, your lordship.
Second document पे बात था 94 submit कर दे लो. That is last. सही तो अंदर नहीं हो ना on plus. Actually this one had been very well. Can you mention? बड़े वैसे.
Item 96.
My lord is adjourning it to the first week of January.
February.
My lord, can we have it on January, my lord?
Third week of
Petitioner was appointed as a laboratory attendant, my lord, on 30th of November 2016. While he was continuing as such, he was terminated on 6th institution. Our agency institution.
We have not filed counter in this case.
Whether counter is required?
No,
I do not.
No, because
the institution they have
filed counter, my lord.
Yeah.
They have filed counter or you have filed reply to the counter. On 6/3/2024, my lord, because I have been terminated, my lord, only 1 minute I will take subject to my list. My lord, since first week of January.
Second week of
Interim to continue. Because terminated, they have published an advertisement, my lord, are protected, not to fill up the post.
96.
Item 97.
May I please, your lordship? This is that matter where lordship's suspended, no proceeding, subsequently revoked. That's why your lordship asked them why you have not paid us.
My lord's directed whether that particular period, whether any disciplinary proceeding is there. I have taken the instruction. In fact, there is no disciplinary proceeding.
Then that period has to be treated as service period only for all.
That I have obtained the instruction.
That was the specific query of my lords that.
By impugned order, what they said?
Well, impugned order, Annex 11, my lord, they have said we have paid, before that, my lord, there was a proceeding and it was culminated with dropping of the proceeding. Then they have said we are releasing the amount. This amount was also released.
And treated as leave.
My lord, kindly come to page 38.
The short grievance of the petitioner is against the order dated 22/10/2024, a copy whereof avails at Annexure 11, which in effect amounts to forcing the leave on the petitioner on the ground that petitioner first. Learned counsel for the petitioner submits that for a short period he was put under suspension in contemplation of inquiry, and that
not in contemplation, not in contemplation. That was also not there. That same revocation, it was also not.
Presumably in contemplation of inquiry, and that even that idea having been given up, the suspension came to be rescinded. And therefore, the said period has to be treated for all practical purposes as the service period, and the benefit should be accorded for the same. First, next paragraph. Learned counsel appearing for the AG, appearing for the OPs, was requested to ascertain whether any proceeding has been pending against the petitioner in connection with the suspension was effected, which eventually came to be rescinded thereafter. First, in all fairness, Mr. Mohanty submits that no any proceeding has been taken up against the petitioner. First, if that be so, the period of suspension has to be treated as service period for all practical purposes, including for the payment of emolument, salary, or the like. Okay. Ordered accordingly, writ petition is disposed of, quashing impugned order dated
22/10/2024 in Annexure 11.
2024. Okay.
Item 98.
My lord, in 94 item.
The consequential benefit should be settled in favor of the petitioner within an outer limit of 8 weeks.
My learned senior,
which the same would carry interest at the rate of 1% per annum per mensum, and that component may be recovered from the erring officials.
My lord, in 94, my learned senior is there. My lord has directed to receive the documents from the tribunal as well as from the director. That I have. May I file it, my lord, today or?
No, you just secure it. We did not ask to file. We told you to keep it ready with you.
We have already received. That was adjourned on mention, my lord.
That's right.
That may be recorded that documents have been filed.
It's indicated that file to be produced. So your just keep that file with them.
In 94?
Yes,
94.
Mohanty submits that he has secured the original file as was directed. Okay.
May I please, madam? On 31st May 2025, the Operating Department number 2 OPSC has issued notice directing that all the MAD candidates, all those candidates who have passed in MAD should file applications. And accordingly, on 21st/6/2025, I have filed applications, but my online applications was not accepted. Whereas now they have the case is matter is pending, or you also have also on 31st/7/2025 issued notice, and interim order has been passed subject to the result. And now the document verification of the similarly situated persons have been made.
But your name is not there.
My name is not there. I pray that it is the matter is settled. There is no res integra. As per the Anand Jadav's case, Anand Jadav versus State of UP by judgment delivered. It says that the both MA qualification and MA in education qualifications are the same. And our High Court also, the coordinator bench of this Honorable Court has also passed the same. And my learned senior appearing for the OPSC also has appeared there, and the judgment is there.
She is senior to you.
My learned senior
colleague.
Now she is she is junior to me. She is my sister. But
now what should be done?
I pray that my offline application may be accepted. I was not seeking for appointment. My offline application may be accepted. Online, in online they are not accepting. And your lordship kindly for a moment Annex 5.
Where is your friend? How can I make an order in his against him?
If your lordship may permit, I will read out the relevant.
They have accepted. They have issued notice to file online applications. But my application, you also can page 49. Only
no, one sentence you have completed. Next sentence you did not.
I could not.
The online applications they have accepted.
Well,
that I have understood.
My application has not been accepted.
Your online application is not accepted.
No, Mal.
Why? Why you not accept online?
The para-wise, and as per the instruction we have, she has submitted her application on 29/4/2024.
When she should have submitted?
The last date of application was 35/2024. She has submitted. What is written in the para-wise?
I do not write your para-wise comments. Your client.
If your lordship may permit, we will file the we'll file the counter.
No, that's all right. But in the meanwhile, what should happen to him?
That is pretty common.
Your he does not want your para-wise.
My learned friend is not my. You see, for page 49. The particular notice has been issued to allowing me, similar situated persons, to file online applications. But my application, I have filed on your lordship 49 page.
Did you file it online?
Yes, but it was not accepted. That's why I prayed for you and I appealed this on court.
Now your senior has come. Yes.
We have received the instruction. Lordship may grant some time. By tomorrow, we'll do detailed instruction.
Tomorrow. We'll call it tomorrow. Wait.
May I pray? Prayer service. Let me. Let come prayer service.
Next.
Item 99.
In item 99, well, I am appearing for the opposite party number 5. And I have already filed my counter. This is for final disposal. My learned friend has filed one IA, but staying the order dated 11/4/2025. A copy of this IA has been served just now. So I want to file objection. And my second objection before your lordship is that managing committee, it's an aided institution. The managing committee has not been implemented as a party. So in absence of managing committee, how this REIT is maintainable?
Well, the grievance is what?
Grievance is for the post of administration in charge between the petitioner and the opposite party number 5.
You are for petitioner?
Yes.
You make a managing committee a party?
No, why, sir?
But who has to make the appointment?
DO is not the appointing authority.
Let me complete. Sir, I was appointed as a headmaster.
By whom?
In the year 1995 by the school managing committee. By that time, the school was a non-aided school.
Yes.
When the school became aided in the year 2004, DO approved my post as headmaster, having 7 years experience. From 95 to 2004, I was appointed as and approved as a headmaster. Thereafter, I draw the salary also in the scale, headmaster scale. But after 5 months,
what's your prayer now?
My prayer is that I am being rotatorily keeping under the juniors. The reason being, is very.
What is your prayer before the court?
prayer before the court is, sir, to cancel the order passed by the DO, making my junior as a headmaster in charge and I become an assistant teacher. But nothing. It is completely arbitrary. And again, rotationally, one man gone, one junior teacher gone, second man gone. Now the fifth TG has been asked to officiate as headmaster and I would work under him.
That is not the case.
That is the case. That is the case I prayed. That is Annexure 5. I pray for a stay of that order. And let me continue as a headmaster. If any disciplinary proceeding, anything management wants, there is no disciplinary proceeding. My learned friend can say, there is no disciplinary proceeding. In absence of any disciplinary proceeding, I cannot be asked to work under my junior. That is the whole submission. That is my prayer. My prayer is to stay that order.
Junior to him.
Yes.
My submission.
I'm asking you.
Yes.
Are you junior to him?
Yes, I am junior.
And you are given in charge of...
Initially, he was appointed as headmaster in charge of that institution because nobody can be appointed or promoted to the post of headmaster in view of the Supreme Court judgment in the case of Pavitra Mohan Das. Because much of water has flowed.
That's another thing.
That 7 years of teaching experience.
Now you are appointed as what?
Headmaster in charge.
Headmaster, no. Headmaster.
Please.
Headmaster.
Please allow me to submit.
May go through the next.
Please allow me to submit.
We'll hear you also.
Yes.
We'll hear you also. You are appointed as in charge headmaster now.
But he was initially appointed as headmaster in charge.
When he was appointed?
But initially, when the school became
long ago
aided, he was appointed as headmaster in charge. Since there were several allegations against him, he was thrown from that post and another person was appointed as headmaster in charge. He handed over the charges to him. Thereafter, my lord, he pressurized that person. He claimed that I will not continue against the post of headmaster in charge. Then thereafter, his appointment was again approved as headmaster in charge by the district education officer.
Yeah.
The other man, he approached this honorable court and incidentally I was the lawyer. And this honorable court quashed that order and directed the district education officer to consider his case as well as the case of another person. And the district education officer took a decision in favor of the another person and he continued to hold the post of headmaster in charge till his death. That order was not challenged by him.
No, that's not right.
Yes.
It is your right. You are a junior to him.
No, thereafter, my lord, I was the managing committee of the school in question, passed a resolution appointing me as headmaster in charge of that institution. That was approved by the district education officer.
That should be
and
correct.
there are severe allegations against him. He misappropriated the school funds.
So hold inquiry.
He misappropriated. Well, that is the resolution. He misappropriated the school funds. Second is he admitted some fake students in the school. I have indicated in my writ petition, and there is no reply to that in the counter. My lord, thereafter, my lord,
No, you can't say all that.
but he has not. Therefore, he has not deliberately implicated the managing committee as a party.
One second. Who has appointed you? Appointed him.
No,
Who has appointed you as the headmaster?
Managing committee.
Managing committee.
But it's an aided institution. There is an approved managing committee.
You implead managing committee as a party.
Sir, deliberately he has not implemented because now these things will come to
you. Speak. Now he's over.
Do you want relief or you want?
I want relief. I want relief.
Then implead him. Implead the management.
Okay, well, I will implead the management, no problem. But the issue is, sir, I should immediately take over the post of the head. I have already taken charge. I cannot work under a junior.
Since 10/4/2025.
8 years junior. Sir, whatever his submission, I am just telling, sir, in one line.
One line I have also told you, but you don't have advocacy skills.
I agree with
you. You are knowledgeable, but the skills are lacking.
No, sir. I tell you that I agree to implement the management.
That is skill. Now you have restored those skills. Petitioner is directed to implead the managing committee of the institution as OP number
6.
OP number 6. First stop. Issue emergent notice to OP number 6. First stop. In the meanwhile, the appointment of OP number,
OP number 5.
OP number 5.
10/4/2025, I have been appointed.
As in charge, arrangement shall continue, but he shall not exercise
Any substantive
power
Yes.
of the post in question till next date of hearing.
Yes.
First, call this matter on 16/12. Complete now, immediately.
Sir, that's just I'm telling orally.
Next.
Item 100.
May I please go on? Even though the present
Yes.
Even though the present petition is eligible for grade B, the gold medal from the National Law University Millets, it was not been awarded in favor of the petitioner. Even if I am the highest CGP holder Millets, even if I am the highest CGP holder Millets, as per the rule, the National Law University Academic and Examination Rule 2023. For a moment, Millets, page 65.
Suppose if I take this matter in the first week of January, whether gold rate will go down or go up?
I am for OP.
There is a report that 30% of hike is possible in the rate of gold.
Lordships, I am for opposite party number.
So you will be benefited. Yes.
I am for opposite party number 3. We need some time to file account.
All these days, what did you do?
Lordship, we couldn't obtain any instruction, but next.
For call this matter in the first week of January 2026. In the meanwhile, counter if any may be filed, failing which petition of government would be taken up along taken with face value.
Grateful.
Thanks.